Hi, Ms. Phillips.
Yes, Your Honor.
Which case do we need to call?
Got a 9 o'clock, 237.
237. Thank
They're
you.
both going to be exactly the same, but I'll explain.
Very well. Calling case 223842237. This is plaintiff Steve Johnson Jr. versus defendant Tyrone Tankersley, Tankersley, and all occupants of 3090 14th Street, apartment number 1. Mr. Tankersley, unmute your microphone, state your full name, please.
He's not present in the courtroom, Your Honor. Ted Phillips,
He's not
OP 35900 for the defendant.
Very well. Mr. Johnson, state your full name, please.
Steve Johnson.
Very well. All right, counsel.
Your Honor, this was adjourned a few days is all, so that Mr. Tankersley could finish moving. He has. Mr. Johnson has acknowledged that to me this morning. I prepared a dismissal order, which I will submit to the court as soon as we're off this case and the next case, and we're done with this one.
All right. All right, Mr. Johnson, you've verified that your property has been vacated and you're going to take possession of it now. All right, sir. All right. Then this case is dismissed. You're all set, Mr. Johnson.
No, he has one more case.
This is another one, same thing. I had 2 7 days.
All right. I didn't know there was another case with you. That I knew it was another case. I didn't know you were on the second case as well. What's the case number on the other one, counsel?
It's 10 o'clock and it's 240.
Okay, calling case 223842240. This is plaintiff Steve Johnson Jr. versus defendant Almonique, ALMONIQUE Littles, LITTLES, and all occupants of 3096 14th Street, apartment number 4.
Morning, Your Honor. Ted Phillips, P35900 for the defendant. The defendant is not present in the courtroom. Mr. Johnson, the plaintiff is, however.
All right, state your name, Mr. Johnson.
Steve Johnson.
Thank you, sir. Counsel.
Your Honor, this matter, like the last, was adjourned for a few days from last week, I think Wednesday, for the defendant to complete moving. She has. The plaintiff has acknowledged that. I will be submitting within a few minutes a dismissal order to the court.
Very well. You said she has moved or she
has moved.
Okay.
Keys are returned and she has moved out.
Very well. All right, Mr. Johnson, this matter will be dismissed as well.
I have a question, Your Honor.
Yes, sir.
I have 4 people in the building. The other 2 that didn't show up, they returned the keys as well.
For other apartments?
It's the same building.
For these apartments? Same building, I understand, but different units.
Yeah, different units.
All right. All right. So did you file a lawsuit on the other ones?
No, I went down when you told me to do the when you told me to go downtown to do the I forgot what you call it. I went down there and did that.
Your Honor, respectfully, I'm sorry, but I wasn't aware of these. Those tenants I do not believe showed up, and there were default judgments entered. I'm fairly sure. I don't know whether Mr. Johnson has followed up by filing a default, but I went downtown
and
filed the paperwork for them too. I went down there.
All right. Well, if you filed the default paperwork, sir, I don't know. So you're saying they moved out as well?
Yeah, you told me, I guess when they didn't show up, you gave me a court date for 10 days, but they returned the keys.
Yeah. All right. All right. So we fought, you came to court. At that time, they had not moved.
Yes.
I gave you a default judgment. You turned in the paperwork, but you're
I went
saying they're
down.
moved since then. They've already moved out since then, is what you're saying.
Yes.
All right, but there was a default judgment that probably was entered, or it may not, I may not have signed it yet. I don't know when you turned that in. But if I signed it already, then there's a default judgment against them. If I don't know what you're asking. Are you saying you just want to dismiss the case now that they moved out?
Yes, they moved the they didn't show up in court, but they end up returning the keys.
All right.
So
Well,
like I said, the building's empty.
All right, I got that, sir. But again, all these case numbers, I have to have a case number. Do you have the case numbers for the other
Yes,
one?
all the numbers is start from 7, 3, 7, 3, 8, 3, 9, and 40. The same numbers, they from 3, 7, 3, 8, 3, 9, 40. So I
Okay,
think
let me see.
I think one is 39 and
All right. Well, sir,
38.
I can't do it like that, sir. I have to know what cases they are. And if you're
Two-
saying that you're moving for a dismissal on them,
You need
go
the
ahead.
case number? It's 22
Yep.
2238 4239.
All right. Mr. Phillips, how do we want to do this?
Your Honor, I've never met those persons, but if it'd be beneficial to the court, I would be happy to meet Mr. Johnson in a breakout
All right.
room, and I can prepare 2 dismissals for those
Very
cases as well. If that would if that would move things along, is that
That would.
okay? Then I will do that, Your Honor.
All right. Thank you.
Sure. Mr. Johnson, I'm going to put you back in a breakout room, and I just need to get some information in those cases.
Right,
Your Honor, I'll submit those as well today.
Thank you.
You're welcome. Have a good Monday. I will be gone after that.
All right. Thank you, sir.
Yep.
Judge Wagner, Gary Sagatti speaking.
Yes.
2732 might be ready.
What? 2732. What time is? Okay, I see it. Mr. McCoy.
Yes.
So did someone talk to Anthony Patrick already? Or are they? No, he's in the breakout room right now, so I don't know who talked to him. They don't. I don't have a attorney listed with them, so I don't know if they put him in the breakout room and they talked to him, or they put him in the breakout room and they talked and they didn't talk to him. They're just waiting to go in, send someone in to talk to him. But he's in a waiting room right now.
Oh, didn't realize that. Thank you.
Good morning, Judge. How are you?
I'm very well, Ms. Gibson. How are you today?
I'm very well. I like the t-shirt you had on today.
Oh, you mean when I forgot that I was on camera and I took my robe off because I left the courtroom and I came back and didn't put it on right away. So
Well, you know what? I like the shirt. That's all.
okay.
May I
And
have
so now you just highlighted that to everyone on YouTube and everything. Okay, thank you, Ms. Gibson. All right.
And at least
All right.
it's a good compliment.
It's a good look.
It's a
All
good
right.
look.
You want to
I
be
agree.
a co-host, right? You
I
want to
would
be a
love to
co-host.
be a
Yeah.
co-host.
You have it.
Thank you.
Okay.
Good morning.
Whoa.
Um,
Go ahead.
Good morning.
But it's still getting, your speaker's off?
My speaker's off. So when you talk, my speaker's off, but for some reason I can't do it unless I'm not in the courtroom with you.
Okay, all right. All right.
I'll change it for you once you talk.
No. I got it. All right, I have someone out here who came in with a telephone. Your telephone number is 6087. I need you to unmute your microphone and tell me your name. Well, you're not muted. Just tell me your name. Person with the telephone number ending in 6087. I need to know who you are. Person with the telephone number. Your telephone number, your full number is 808-6087.
Gregory Miles.
Gregory Miles. All right, Mr. Miles. All right, Mr. Miles. I got your name. What's 1 second. Mr. Miles, what's your case number?
058043120.
That's not a case number for us. So that's probably traffic. Is that traffic number?
Yeah,
I don't recognize. What kind of case do you have, sir?
it's 331, courtroom 331.
Yes,
It's,
this is you're not in 331 now. You're in a different courtroom. You're in 535. So you have to go back out and go into 331, sir.
So
If you when it asks for the courtroom number or the Zoom number, you put in 360-331-0000.
360-331-0000.
That's correct.
At the same number I called, right?
Yes, when it asks for the courtroom number, that's what you put in. You don't put in the one with 33. You put in one with 535 now, but you put in 331. All right.
Oh, so you saying 535-331-0000?
No, sir. To come in here, you put in 360-535-0000. That's the wrong courtroom. You got to go 360-331-0000. The 3 digits in the middle are different.
So 331.
Yes,
You go.
that's
Okay.
the courtroom number.
Okay, thanks.
All right.
Because the water's too cold, I have to mix it.
You said water's too cold?
I have to mix it.
Good morning, Judge Warren. This is Michael Lamb. Can I have control, sir?
Yes, sir, Mr. Lamb. Let's see. No, you are co-host now, sir.
I am. Okay. Okay. Thank you.
Yeah.
Tayshawn Brown, can you accept the invite to the breakout room?
Ms. Franklin,
Yes.
the breakout room is set up now that they will go directly in. They don't have to accept. So if you send the signal, they should go directly in.
Let me resend it.
Is there an attorney needed to speak with Mr. Brown? I'm having trouble exercising my controls.
Mr. Lamb, what are you trying to do? I don't show a Mr. Brown in the general courtroom. Let me see if he's already in the breakout room. He's already in the breakout room, counsel.
Attorney Lamb,
Miss-
you do need counsel.
He does. Okay. Okay.
Do you want me to place you in there?
Please.
Are you talking about with Mr. Brown?
Yes.
Attorney Moore is in there right now. In breakout room 1, there's
No,
a
I'm not talking
Decoria,
about, I'm talking about a different Brown.
a different Brown. Okay. Tayshawn Brown? Oh,
Yes.
yeah. In room 8, yes. Yes, just Ms. Franklin is in there now, so, but no attorney.
Okay.
All right. Multiple Browns today.
Good morning, Miss Bonnie. Hello?
Good morning, Ms. Blaney.
Yes. Good morning, Judge. I know I'm here on a Monday, but I wanted to make sure. I thought there was a Shelby Smith for this morning at 10.
Shelby Smith. I don't have that on my docket, but we will, do you know the case number?
If you'll give me one moment.
Yeah, I was surprised to see you on a Monday.
I just love being in court so much.
We're gonna have to talk about your mental state.
I get that. Hold on one second. I do not have that case number. For whatever reason, it's not in here.
Miss Bonnie is good, but not quite that good.
I'll be back in a couple minutes then, and I apologize. I didn't have that number available right this moment.
No problem. No problem.
Mr. Sagatti, are you available to speak concerning the McCoy matter?
Yes.
Judge, I have the number now.
Y'all need me to place y'all in the breakout room?
Please.
Okay, I'll do it.
Help out Mr. Lamb, Ms. Gibson. All right, yes, Attorney Blaney, we're ready for the case number.
223-819-67.
It's on the document today, but it don't have her name listed. That's why I see it. It just has all occupant.
Oh, okay. All right.
You said 223-819-67, right?
Yes, ma'am.
Oh,
And
yeah.
Catch that
10.
10 o'clock.
all right. Well, I am on that case. And
That's with Attorney Cox or whoever standing in for him today. Mr. Horka is here. Mr. Horka?
Yes, sir.
Is that your case? The ending in 967, Gerson Seppin?
Yes, Your Honor.
Okay.
may I have permissions?
Yes.
Mr. Horka, can I talk to you in a breakout room?
Yep, I'm available.
All right. Mr. Horka, if you'll just go back to 4, I'll go in there.
All right, there's someone out here and you're on the telephone. Your last four digits are 9708. 9708. I need to know your name.
Hello? Hello?
Yes, what's your name? What's your name?
Winston. Penn Winston.
What's the first name?
First name is Penn, P-I-N.
Okay, and last name is Winston. What's your case number, Mr. Winston?
Case number is 223833200.
What time were you scheduled for? I see
9
it.
o'clock.
All right, Mr. Winston. Just mute your microphone. You'll do that by pressing the star sign and the number 6, *6, and leave it that way until we call your name.
Thank you.
Okay,
Can you try talking again? No.
but that was P.N. Winston,
Oh, Ken, I'm sorry.
P-I-N. So. See, P.N. Winston, so he was on the case. You know, on this one,
Hello? Yep.
all right, I have someone out here that says Patricia's iPhone. Patricia's iPhone. I need to know your name.
Patricia Sykes.
What's the last name?
Sykes, Sykes.
Okay, Miss Syke. Let's see if I see your name on the docket. All right, I got your name, ma'am. Just go ahead and mute your microphone. Leave it that way until we call your case.
Okay, thank you.
You changed it?
Your Honor, this is Attorney Matthew Carey. I'd be ready on case ending in 200 with Mr. Winston, who I think needs to speak with an attorney still.
Hold on 1 second, sir. I'm in the middle of doing something. 1 second. Now, all right, counsel, Attorney Carey, what case do you say you have?
Ends in 200 with Mr. Winston, who just checked in.
Okay. All right, Mr. Winston just checked in. As soon as one of the attorneys talk to him, then we could call the case.
Okay, thank you.
Attorney Fluker.
Good morning. How are you this morning?
Very well. How are you this morning?
I'm doing well, thank you.
I don't see your name on any cases out here today. What case do you have?
I was just checking in. It was supposed to have been, I believe, dismissed, but I never saw the dismissal because it's in circuit court. So I just popped in to check status. It's 22-381201, Dyke O'Neill v. Belinda Coleman.
All right. I don't
There's a case
I don't
filed
see.
previously for circuit court. It was supposed to have been a dismissal.
Well, if it was a dismissal and I got it in here, I won't have it on my docket. So we'll check the number. It's 223-820. I'm sorry, 82801. That's the case in Judge Brew's courtroom.
Okay, that's Dyke O'Neill v. Belinda Coleman.
What's the caption on it?
Says the plaintiff is Locust Properties.
No,
and the
no.
defendant is.
This is Dyke O'Neill, 22-381201.
Oh, we do have that, but that's not the case number you gave me.
Okay, I was about to say, yeah.
Or I didn't write it down. I had 801 on here, not 201. I do see that case, Dyke O'Neill versus occupants, as scheduled for 10 a.m.
Right.
I haven't seen anybody appear on it for either side. So, and
Right. We were here.
are
last
you?
time. We pushed it out, and caption was changed. I filed answer from his defenses because it's a pending matter in circuit court that was filed previous to this, and summary disposition motions have been filed, but they haven't been decided yet. The judge had a trial, so that got pushed back on the decision.
So this is before circuit court now?
Yes.
All right. So is this case? So this case is being dismissed because it was filed in circuit court then?
Well, before you just pushed it out, so I was just appearing for status, and I'm sure my opponent will status too.
Well, I mean, it's got to be in one court, not
Right.
Well, unless it's a separate issue that is a circuit court issue, but I don't know what. Anyway, so it's not dismissed. We actually have a schedule for today, so I don't know what's going to happen, and we'll when the attorneys appear, we can see counsel.
All right. Thank you.
Mm-hmm. Two 201. You know what's interesting about
Ms. Gibson, might you be able to place me back in the breakout room with Mr. Patrick?
Sure can.
All right, I have someone out here by the name of Shelby Smith. Shelby Smith, unmute your microphone, please.
Yes.
Ms. Smith, what's your case number?
Give me 1 second. It is.
That's my case, Your Honor.
That's your case, count. All right. What? You're ready on it. Okay. I still need the
Oh, the case number.
numbers.
Worse, I'm not ready with it though.
I have it, Judge, if you need it.
I do. or just to call it. I just give me the last three. Everything is at 9 o'clock or 10 o'clock. So give me the last three and I'll pull it up.
967.
5967.
No, Judge. 967.
Okay.
Thank you, Ms.
967.
Yes. You're welcome, attorney.
So is Ms. Gibson your legal assistant for the summer?
She's a legal assistant with United Community Housing Coalition.
Oh, okay.
All right. Ms. Blaney, who's that's Mr. Horka. Calling case 223811967. This is Gerson, Gerson Sepin, SEPIN, Detroit Renaissance Fund, LLC, plaintiff versus Shelby Smith. That's SHELBI Smith, and all occupants of 17420 Prairie, City of Detroit. Ms. Smith, state your full name.
Shelby Smith.
All right.
Mary.
Attorneys.
Mr. Horka? My apologies. I thought he was still out here, Your Honor. I guess we're not quite ready then.
Okay, let me take a quick look and see where Mr. Horka might be. All right, he probably went to a different courtroom.
All right.
Well, all right, we'll recall it.
Thank you, Your Honor.
Miss Shelby Smith, just hold on. The attorney is not in the courtroom right now. We'll recall the case as soon as he comes back.
Okay, thank you.
And I do see Mr. Stern here, opposing counsel on my case.
All right. So does that mean we're ready to call the case?
Yes, sir.
All right. Calling case 22381-201. This is Dick O'Neill, Inc. versus any and all occupants of 1066 East Grand Boulevard. It looks like we had someone self-identify on an earlier date. It looks like it's Belinda. I'm not sure about the last name though, because I'm tired reading the writing. Is that Hector?
Belinda Coleman Hilton.
Hilton? Oh, okay. Whoever wrote this on here is just not very clear. Hilton. All right, thank you. All right, Ms. Hilton, you've already put your name on the record. Attorneys?
Good morning, Your Honor. Ryan Stern on behalf of the plaintiffs, P57897.
Good morning, Your Honor. May it please the court, Vanessa Cooper on behalf of defendant, now occupant of Belinda Coleman Hilton. This is ancillary to proposed purported mortgage foreclosure that has an ancillary case pending in the circuit court.
Oh, Ms. Fluker, for whatever reason, you're not coming across clear. Court reporter is just indicating to me she couldn't, and I was struggling myself. I don't know if it's your device or maybe a little louder, or see if we can get you. All right.
Vanessa Fluker, P64870 on behalf of defendant Belinda Coleman Hilton, and that was identified before Judge Garrett, not the occupant. This is post foreclosure, and there is a matter in circuit court, as the court may recall, and we were awaiting a summary disposition decision, which we don't have yet.
All right. So this case is in circuit court right now. Is that for a quiet title or what is it for?
It's a challenge. That's one of the counts, but it's a challenge to the mortgage foreclosure, misrepresentation, fraud, violation, MCL 63204, a list of things.
Very well. Attorney Stern?
Yeah, Judge, Ms. Fluker, I'm sorry, the defendant filed a action in circuit court challenging the foreclosure. There is a motion for summary disposition that's been pending for quite some time. Judge Brian Sullivan in the circuit court just hasn't gotten to it yet. We're waiting on a response from that.
Okay.
Circuit court, I I mean, the entire action in the circuit court is based on a defect in title. Well, the defendant's alleged defect in title. There is no defect in title. I've presented all the docs to this court also. I guess I'll leave it up to this court as to what they want to do.
Oh, I'm not going to take any action if it's pending right now in circuit court.
All right, that motion for summary should be decided any day now. It's without oral arguments, Judge.
Okay.
Yeah.
All right.
For the judge to make a decision.
We'll wait to see what Judge, you said Brian Sullivan?
Yes, Your Honor.
Correct.
Very well. We'll wait to see we'll wait Judge Sullivan's ruling.
Okay, Judge. So I don't know, can we maybe adjourn this out 10 days, 2 weeks?
We'll do 2 weeks. Let's see, we are on the 25th. Actually, 2 weeks is probably, yeah, that's probably too full right now. I'll probably have to go until the week of, because this court is not going to be open the week of August 15th, so we'll have to go August the 22nd.
August 22nd, Your Honor?
Yes. At 10 a.m.
Okay.
Okay, Your Honor. Sounds good.
Thank you.
Thank you, Your Honor. Have a great day.
You as well.
He just received whoever. I mean, I'll check and see if I can pull, see if I can get to judge.
Can I be placed in a breakout room with Mr. Sagadi? I'm sorry for the interruption. This is Michael Lamb.
Sure can.
Ms. Gibson, are you helping Mr. Lamb?
Yes,
Okay. Mr. Lamb, remember her at Christmas.
please.
I'm a Jehovah's Witness, Your Honor. No, I'm just playing.
Remember her birthday. All right, I see someone out here says Jasmine Milan. Jasmine Milan, unmute your microphone, please.
Sorry, I'm not sure if I'm in the correct courtroom.
Well, that's what I'm calling to find out, ma'am, because I don't see you on my docket. What's your case number?
I don't have it. I don't have it. I'm sorry.
Is it a traffic case or is it landlord tenant?
Traffic.
All right, you're in the wrong courtroom. You want to go in courtroom 360-331-0000.
Oh wait, I'm not gonna remember all that. What was it again?
360
Huh?
331
Okay.
0000. That's the room, Zoom courtroom number. When
Thank
you go out
you.
on Zoom and that's okay. All right. John Gwynn.
Yes, Your Honor.
All right, you're an attorney?
Yes.
All right, sir, when you come out on Zoom, I need you to put out there that you're an attorney or put your P number out there, actually put your P number out there. So when I look at the screen, I know I don't have a defendant or a plaintiff on a case. So,
Okay, Judge.
yes. What case are you on, sir?
I'm on the 10 o'clock docket 914.
914. Oh, I do see your name out here on there. All right. If one of the attorneys have talked to the defendant, Ms. Makisha Jones, she is out here, so I don't know if anyone's talked to her yet. Let me look in the breakout room and see if I see that an attorney has talked to her.
Yes,
She's in a breakout room. Yes, sir.
I'm sorry, Judge. At the last hearing, Anthony Green was consulting with Ms. Jones.
We don't have Mr. Green here today, or we don't so far. We'll find out if that's going to someone else.
Okay, thank you.
Excuse me, Judge, if you give me the name, I'll look it up in our case management system.
Okay, the defendant is Makisha, Makesha Jones.
All right, thank you.
Mhm.
Judge Wagner.
Yes, sir.
This
Yes,
attorney,
sir. Yes, sir. Mr.
could I
Abbott.
be put in a breakout room with Ms. Boyke?
Okay, okay, yes. All right, let me see something. I think Ms. Boyke should have privileges to do that, but let me make sure. Yep, she's a co-host.
Do you have a room in mind, Attorney Abbott?
I'm sorry, what?
Pardon me?
Is there a breakout room in mind?
You know what? Anything in 9, 10, 11, 12, 13, they're all open. So just pick one.
I'll hop in tonight then. Thank you, Your Honor.
Sure, my kid. Where's your mic?
All right, I have someone on the screen. It just says user. I'm sending a signal to your device to tell you to unmute. Oh, it went away.
Your Honor, I've sending a message out to Mr. Attorney Green.
Okay, great. Thank you.
Ms. Gibson, good morning again. This is Michael Lamb. Might I be able to will you please put me in the breakout room with Mr. Patrick?
I sure can, Attorney Lamb.
Thank you.
Can you sign this?
Good morning again, Judge Wagner. This is Michael Lamb. I'm ready with a matter that was scheduled at 9 o'clock. My belief, though, is that the tenant might still be in the breakout room.
Mr. Lamb, I can check that. Actually, you can check that as well. You can look at the breakout rooms and see, but we're going to have to work on you, sir. So, Who's the person?
Anthony Patrick. I'm sorry.
Anthony Patrick. When you came out of the breakout room, Mr. Patrick stayed in there. So you have to sometimes tell them that they have to click on and leave breakout room. But I will bring him out.
Okay, and I believe I said his name backwards, but
okay, that's okay. Well, I don't know which one it is. On the screen, it says Anthony Patrick. So sometimes they put last names first. If you got two names, that could be first or last name. So, all right, Mr. Patrick or Mr. Anthony Patrick.
Yes, sir.
All right, is that your name, Anthony Patrick, and not Patrick Anthony?
It's Anthony Patrick, Honor.
Thank you, sir. All right, counsel, you want me to call this case? This is case. You've already talked to Mr. Is Mr. Sagatti here? Or yes, Mr. Sagatti is here. Let me call this case. 732 at 9 a.m. Calling case 22382-732. This is plaintiff Charles McCoy versus defendant Anthony Patrick and all occupants of, do I have an address here? 1 second. And all occupants of 18030 Norwood. Appearances, please.
Gary Sagatti, Your Honor, on behalf of Mr. McCoy, P39047. Mr. McCoy is in the courtroom with us.
Mr. McCoy, state your full name, please, for the record.
Charles McCoy.
Thank you, sir. Mr. Anthony Patrick has already placed his name on the record. Mr. Lamb?
Good morning, Your Honor. My name is, my P number is 79816. I'm appearing on behalf of Michigan Legal Services, and I did provide some advice to Mr. Patrick as well as advocate on his behalf. I also spoke to Mr. Sagatti concerning this matter. We do have a resolution, Your Honor. Let me first state that Mr. Patrick was the victim of a fraudulent deed. Mr. Sagatti provided me with some information concerning the historical conveyance of the property that is the subject of this claim, Your Honor. It seemed to identify that, again, Mr. Patrick was the victim of a fraudulent land conveyance. In any event, Mr. Sagatti and his client have agreed to give Mr. Patrick $1,000 in that he would leave the property in 10 days and also submit to a walkthrough, as there are some light fixtures that are in controversy as relates to who should be taking them. The intent is for the parties to go through to ascertain who should be taking what fixtures. And again, Mr. Patrick is going to get $1,000. He's going to sign a quick claim deed and vacate the premises in 10 days.
Very well. Mr. Patrick.
Yes, Your Honor.
All right. I know we were last here on July the 12th, 2022. And at that time, both you and the plaintiff indicated you had deeds. Based on some research, now we know that your deed is a false deed, and that doesn't mean that you knew that. And we have fraud perpetrated on people all the time. So the agreement that the attorney just put on the record, that's what you understand you're going to do, sir? You're going to leave the property within 10 days, and you're going to be given $1,000, and you're going to have an opportunity to walk through the property to determine if any fixtures should remain, or if you can take any with you. Is that the agreement, sir?
Yes, Your Honor. Can I ask a question, Your Honor?
Yeah, go ahead, sir.
Mr. McCoy didn't purchase any of those fixtures, so why should he be able to keep them?
Because in what happens, sir, is fixtures go with the property. If there is a fixture that's in the property, let's say you're a tenant in the property and you put fixtures in there, that becomes the property of the owner. the owner's property. That's just the way that it works, because that's why when people come into a house, of all the lamp fixtures or the things, the ceiling, chandeliers, stoves and things like that, if everybody just took everything out, that house would not be habitable. So once you put something in there, unless when you're leaving, if there's not an agreement with land, you know, you like if you selling your home and if you don't put in there an agreement that the new owners are allowing you to take it with you, you can't take it, sir.
It was uninhabitable when I moved in, Your Honor.
Doesn't matter. It wasn't your, if it wasn't your property, you can't just do
Okay.
that. So even if you thought it was your property.
Okay.
So that's why they're gonna go through, at least they're saying they're gonna do a walkthrough with you and they're gonna make a determination. At least they're just not saying that you can't take any fixtures with you. So at least it's something that's gonna be negotiated.
Yep. Thank you, Your Honor.
All right.
Okay.
All right, sir. So we're all set then, sir. You're gonna get the $1,000. You have, but you have to leave the property within the 10 days. Yes.
Your Honor, Gary.
When does the
okay.
10 days start?
Hold on 1 second, sir. Mr. Scotty.
I just wanted to, I was taking notes as Mr. Lamb was talking. I just wanted to make sure I got it all covered. Going to vacate in 10 days and sign a quit claim deed over to my client, relinquishing his cloud deed. In exchange for that, he will receive $1,000. For purposes of the timing, we can work through our respective law offices. Mr. Patrick can come to my office, sign the deed and receive it, or Mr. Lamb's. That's something we can work out outside the court. We're going to enter a judgment today, which will be vacated if he does sign the deed and vacate in the 10 days. My client would like to cut the grass. It's quite high in risk of a blight ticket. And there's an abandoned car in the property. This is something Mr. Lamb and I did not discuss, so he's hearing this for the first time. My client would like Mr. Patrick to remove the abandoned car.
All right, Mr. Patrick.
Yeah, I'm moving all my stuff. That's not a problem.
Okay, all right. First I was gonna ask, was it your car that was there? But you said you're gonna move it. That's fine. All right. All right, the agreement is set. Yes, Mr. Patrick.
When would be the 10 days and when do it start?
10 days from today, sir. So today, and I'm gonna give you the date. Today is the 25th of July. August the 1st is 8 days. What that means, that's August the 3rd, sir.
All right.
One final point, Your Honor, Mr. Patrick. When can our respective clients do the walkthrough on the property, either today or tomorrow?
Neither. I work 10 hours a day, so by the time I get off, it'll be 8 or 9 o'clock.
I think that
time. Let's see. All right. So, counsel, he's going to be out of that property. Got to be out of the property August 3rd. Could he? If he's working every day, could you do it on Saturday the 30th?
Mr. McCoy?
Yes, I can, Your Honor.
That good for you, Mr. Patrick?
Sounds good.
All right, now we're gonna get a little more detail. What time is it gonna be?
I'll be off, so that's up to Mr. McCoy.
9 a.m. if that's fine.
That's a little early. How about 10?
10 a.m. is fine.
Yep.
All right.
So I believe, Your Honor, real quick, I'm sorry, but I believe the 10 days gives Mr. Patrick at least until the 4th of August. So can we say by the close of business?
Well, hold on. Let's make sure that my math isn't fuzzy. It's 31 days in July. So 25 is today. So that's 26, 27, 28, 29, 30, 31. August the 1st would be 7. August the 2nd would be 8. You're right. August the 9th would be 9 days. So that would be August the 4th. You're right, sir.
So can we agree to close of business by the 4th?
Yeah, he has to be out of the property owner before the, yes. Actually, that goes to midnight on the 4th. That's the way it works, so. But he has to be out on the 4th, so.
And final point, Your Honor, Mr. Lamb has not filed an appearance. Shall I submit this to him for his signature and his client's approval? How are we going to work that last little piece?
Mr. Sagadi, while I don't plan on filing an appearance, I certainly can facilitate the signing of the document. Yes, I can get it into Mr. Patrick's possession and get it back into your possession for signature, honor signature is appropriate.
So I'll email it to you, Mr. Lamb.
Fair enough.
And the keys, I'm sorry, Your Honor, but I was just mentioning the keys. Can we get that mentioned on record?
Well, he has to have the keys until the 4th, so unless he moves out prior to that. So as long as he makes arrangements for you to get the keys on or after the 4th, sir, he can make arrangements. Is there a mailbox? Can he leave them in the mailbox for you on the 4th, and you can pick them up there? Or
Yes, sir.
If in fact he wants to make arrangements with you at that walkthrough time, you just have some arrangements where he can give you the keys, turn the keys over to you.
Thank you,
Your
sir.
Honor.
Yes.
My locks are hubbed, so what I can do is I can put the old locks back on because those run on the internet and they got a hub key. So I can take those out and put some new locks on there because I mean, yeah,
That's fine. So, long as you have the locks to the keys, the keys to give to him to the house. So if you got something where you got electronic locks and you go through it on the hub and those are yours, I don't think he's going to have a problem with that. As long as you get he has keys to the place.
Yeah, okay. I just want to make sure that was coming with me.
All right.
Your Honor, last question
yes.
for Mr. Patrick. Mr. Patrick, did you complete the intake process with Ms. Franklin?
Yeah, yep.
Okay, perfect. Okay, thank you.
All right, we're all set there.
Yes, we are, Your Honor. Thank you. Mr. Lamb, may I talk to you in the breakout room momentarily?
Absolutely.
Thank you. Do we just go back to where we were? I was assigned to break room 5.
I'm assigned.
Let me take a look. Let's see. Both of you were in, what breakout room were you in, counsel?
5.
All right, you could go back in there. Mr. Lamb, we could put you back in there.
Okay.
All right. Thanks, Judge Wagner. Have a good day.
Thank you. Thank you, sir.
Your Honor, I can leave now?
Who's speaking?
Patrick.
On the last case that we just did?
Yes, sir.
Okay, no, we're all done, sir. You can't talk to me without the other parties out here, so. You're all set. You can sign off, sir.
Okay, then. Thank you. That's what I was asking. Have a great day.
Yes, you too.
I'm in court.
Hello,
What's your name, sir?
Anthony Lewis.
Hold on, Mr. Lewis. Mr. Lewis, what's your case number?
I don't have the case number right now. I'm currently at work.
All right, but that doesn't help me, sir, because I don't know who you are or what your case number is. That gets mailed to you. So how did you know to come out here? What did you have to come out here on the Zoom courtroom, sir?
Well, I got a paper in the mail, but I'm
All
not
right,
at
so
home.
what's the case number on it? What's the case number on
I
it?
don't know the number on the paper. I don't have the paper in front of me right now.
So how did you know what courtroom to come to?
I really don't. I'm looking for the courtroom now.
Mr. Lewis, when you come to court, you need to have information on your case. I have literally thousands of cases. You come out and say your name. I don't know who you are. We go by case numbers. You say Anthony Lewis?
Yes.
Could you punch in Anthony Lewis? Yes, I don't know. Is it a landlord-tenant case, sir?
Yes.
I don't see any cases popping out right away.
Your name doesn't pop up. Are you an occupant, sir, or is your name on the
Yes, I'm on the lease. Yes.
Well, I don't see anything out here for you today, sir, because let me keep looking. Nope, I don't see anything that says Anthony Lewis on it.
Okay, thank you.
You need to find the case number, sir.
All right.
So because I don't know what courtroom you're in. It could be multiple courtrooms, sir.
Okay.
Well, hi, Judge, my apologies. This is Andrea Gibson.
Hold on one second, Mr. Lewis.
He left.
Ms. Gibson?
Sorry, he left. I was trying to see
Shit, how do I get out?
if he was with.
I see Anthony Lewis out here, but I don't know if this is him, but that's for Judge Bruce, not us.
Okay. I was trying to find it for him. Never mind.
So we go in.
He'll come back, I guess. So.
Your Honor, could I be placed in a breakout room with Shelby Smith, please?
I will make you co-host.
That'll work too. Thank you.
Okay, Your Honor, Mr. Horka and I have a matter. We're ready to go on if you're ready for another case.
I'm ready, counsel.
It's
What do you
the
have?
9 o'clock ending in 981.
All right, calling case 22380981. This is Mr. Mark Fisher, plaintiff versus defendant. I have Miss, it says Chistrin. I don't know if that's just spelled wrong or not, but it says CHIS. Hold on. What's on the file is CHISTRAN Brown and all occupants of 15859 Carlisle Street. I also have someone who self-identified of a Taishan, TAI apostrophe SHAWN Brown, and also have a note here that that's a 17-year-old. Now, is your name spelled wrong on here? Chistrin, what is your name?
I'm Tyshawn Brown, but my mom's name is Kristen. It's KRISTYN. They spelled it wrong.
Okay. And you're Tyshawn Brown. You're 17 years old?
Yes, my uncle is also here.
Yes,
He's
Your Honor.
an adult.
Your Honor, for the record, Sharon Moore, P70411, Michigan Legal Services, here on behalf of the defendants. And yes, Tyshawn Brown is a 17-year-old minor who is an occupant of the property. Her uncle, Decorian Brown, who is present here on Zoom, has or is getting documentation to operate as power of attorney for Kristen Brown, who is unavailable at this time. So we'd like you to, Decorian Brown, please unmute your device and give your name for the court.
Yes, ma'am. My name is Decorian Brown.
Okay. And counsel, what is the plan here?
Well, I'm sure Mr. Horka is going to have some issue with this because this is like the 5th adjournment of this case. But unfortunately, Your Honor, this case was originally being handled by an attorney from Lakeshore Legal Aid. Due to their organizational restrictions, they had to withdraw from this case at the, I believe it was 4th or 5th hearing. This is my first encounter with this case. I've been talking with everyone and I'm attempting to get records and information to figure out what is the next course of action for this family. I've asked Mr. Horka if he would agree to an adjournment. Unfortunately, due to my personal circumstances, I need 30 days, but that means that it'll have to go beyond, it'll have to go till September 19th because of my personal circumstances. So
well, counsel, can we get someone else from your office on this case? Because
if Your Honor would give us a 30-day adjournment, I will get someone else to cover this case and handle it with the, and I will definitely like give them a full write-up and memo of understanding so they know exactly the status of this case and what needs to happen or what could happen.
Mr. Horka.
Yeah, good morning. Joe Horka, P75969 for the plaintiff. This is an unusual case. It's our 5th hearing here today. I am objecting to any adjournment. My client has no protection with an adjournment. We can't ask for escrow from a minor. I have a warranty deed indicating my client is the sole owner of the property. The defendants have no right to possession at this point. We've let this play out for 5 hearings and we've made no progress whatsoever on title dispute, on proving a right to possession, on anything that should prevent this case from resolving itself today. We asked the court for a judgment. If there's motions that need to be filed in this court or other courts, they can do that. But there's been nothing here to stop this action from resolving itself. My client shouldn't have to incur attorney's fees. They shouldn't have the defendants living in there rent-free. It's my understanding there are no adults currently living in the home. That could be a health and safety issue. God forbid something happens to these minors.
There's our adults in the home.
Yeah, I was going to say, Your Honor, there is an adult in the home. The grandmother comes.
The
grandmother comes over. The uncle comes over regularly. So the children are not. Okay, Mr. Brown.
Mr. Brown, stop talking now. Okay, we'll get to you. All right, go ahead.
They do have adults in the home. It's just a legal matter of Mr. Decorian Brown can't act on his sister's behalf until he has the power of attorney document. And that's, and that is something that is necessary in order to secure other housing for these children. And he cannot have them move in with him because of his circumstances. So he's, in order to procure housing for them, he's going to have that power of attorney to act.
Yeah, this was filed in May. Our first court date was in May. We're at the end of July, and now we're asking for end of August. Again, with no progress as far as I'm concerned. If I made a misstatement about adults living in the home, then I apologize. But I'm not aware of that personally. And that would be unauthorized occupants that haven't been given a permission to stay there as far as I know. So
Your Honor, Your Honor, there's I'm sorry, I didn't mean to interrupt Attorney Horka. I just wanted to state that they've provided no lease. So they've not stated that there's a lease to which there's a restriction on the occupants in the house.
Counsel, I understand what is being said, and I don't even know if what is being said is actually being said. In other words, that Mr. Brown has said he's in the house. The grandmother said, you said she comes and checks on. So I don't know what in the house means. I don't know if that's temporary just for checking on them or assisting in some form or fashion. I do recognize this is, you know, one of those cases where I look at and I say, wow, you know, there has to be a mechanism, there has to be a process, there has to be a way to care for some minors that does not impose upon a individual who has no relationship to them at all. It's, you know, for Mr. Porker's client, it's a business, and then that's what it is. Sometimes we expect or hope that businesses are good corporate citizens or good citizens, and they will assist in circumstances where someone is in distress. And that's what we have here. We have, I just happen to remember this case because it breaks my heart. When the individual, the young lady, spoke up and said who she was and told us she was a 17-year-old, and there was someone else who was a little bit younger, and then there was, I believe it was a young lady who was somewhere around the age of 8. Due to circumstances which I don't know what they are and how long they might be in play, but the young ladies indicated that their mother was incarcerated at the time. I don't know if that's jail or if that's prison. I don't know if it's a short period of time or a long period of time. I recognize that if in fact there's just a straight up eviction, that could potentially put minors on the street. I'm now hearing that there's an uncle involved and maybe a grandmother. I would hope that if in fact it comes to this, because the landlord does have the right to take their property, I would hope that one of those individuals would take them in. I don't know if that is possible for the uncle. I don't know if he's just coming over as a person checking to make sure that they are safe and secure. I don't know if he has his own property or own place that he could maybe temporarily house them in. I don't know. I don't know if that situation applies to the grandmother. All I know is if we do an eviction today, in 10 days, potentially 3 minors could be homeless. And that is, to me, a very, very tragic situation. But as I've said on other occasions, I cannot impose what is a societal problem or some, you know, on an individual. They could be good people, but need their property back. They could be very Scrooge. It doesn't really matter. It's their property, have the right to ask for it back. And I don't know what happened on the earlier cases. I show the first time it was before me was June the 3rd, 2022, when we adjourned it to June 21st, I think, or June 21st. That's when I realized, and it was put on the record, because the young lady who was 17 years old spoke and said, because I sometimes ask, especially if I hear a voice that sounds very young or tender of age, how old you are. And that's when I found out that she was, you know, a minor, and that there was 2 other minors in the house, and it caused me to question how did that come about. And she indicated her mother was locked up. And at that time, we did an adjournment because I thought it would be an opportunity for the agencies to find something, because I believe there was some discussion before that would cause the children to be separated, like some type of youth services that would only take up to a certain age, and then it would cause them to be split up. And I think that would be even more tragic.
I'm signing off, Jim.
Mr. Abbott, mute your microphone. Thank you. I hope that there are some agencies that can help. I hope that, and counsel, I don't. Mr. Horker, are you asking for 10 days or a little bit more?
You have 30 days, Your Honor.
Okay. Thank you, Mr. Horker. Ms. Moore?
Your Honor, 30 days is still not sufficient time for these. I mean, literally, they cannot go out and find other housing. They cannot do that.
Okay,
Mr.
I
Brown
understand
can
that.
attempt to, Your Honor, let me just provide the court with a few other details, okay? This is not necessarily a business situation. The deceased, Mr. James Fisher, who was the husband of Bernice Fisher, the grantor of this property to Mark Fisher, was in a relationship with Kristen Brown. Interviews and talking with the children say that this has been their home. They understood this to be their home, that James Fisher helped their mom buy it. Unfortunately, he was still married and he died before the property was actually transferred. So it's not like just a business transaction, Your Honor. This has been their home. Unfortunately, their uncle, Decorian Brown, is in a living situation where he cannot just bring the children into his home without risking his loss of housing. I have not been able to reach the grandmother today to explore what are the housing options there. To put them under this sort of Damocles to say, you've got 30 days to figure out what you're doing. Your Honor, I would even say is tantamount to child abuse. It's putting them under a stress that they can't even resolve. They have no options. And what will happen is that they could then become wards of the state, which then puts them under further stress, further disruption to their life. We are asking you 30 days to come back with a plan, not 30 days for them to like be out on the street or figure out what to do. 30 days, we will have a plan. I will make sure that someone in my organization is here for that. I understand that Mr. Fisher has his property, wants to do something with it. We're not trying to stop him from that. We're just trying to allow them to move in an organized fashion. They've been living there for years. The Fishers haven't received rent from them in all those years. So it's not like, oh, they're suddenly losing out on something that they got before. So we're asking Your Honor to do what the court has the power to do, which is to grant a little additional time in this, which is a very special circumstance, which is very warranted.
Please.
The problem, counsel, is I don't, go ahead.
We're just saying, Your Honor, please give them the time so that we can come back with a solution. Because the difference between saying you have 30 days to get out and 30 days to come back with a plan is humongous. That stress is almost incalculable.
And I don't disagree with you, counsel. I disagree with what the authority that I have to do. I don't think I have the authority to tell someone else they're not gonna get any money and they can't do anything with their property. I disagree with that 100%. I don't, I sympathize and I wish that there was something that I could do. I just don't believe I have the legal authority to do something like that.
All we need is just time to get out, Your Honor.
Sir, I understand what you need. I'm talking about what I can do legally. So I know what you need. And my heart tells me that that's what.
Your Honor, let's adjourn this 2 weeks, and I will take that time frame into consideration with the time I offered. But I want to give Attorney Moore 2 weeks to see what she can figure out in the meantime.
Okay.
Okay. We'll adjourn it for 2 weeks. Thank you, Mr. Horker. So.
Okay.
All right. All right. 2 weeks from today's date, today being the 25th. Yes, the 25th. 2 weeks from today's date would be August the 8th. August the 8th. All right.
At 9 a.m., Your Honor.
It's going to be 10 a.m.
All right. Thank you, everybody.
Thank you, sir.
Thank you, Mr. Horka. Okay, thank you, Your Honor. Mr. Brown, I will be in touch with you. Tashawn Brown, I'll be in touch with your uncle and he'll talk to you, okay?
Okay, thank you.
You're
Thank
welcome. Attorney Matthew Carey, can we talk in a breakout room?
Yes.
I'll send you a request.
Thank you.
Your Honor, we're ready on the Shelby Smith case.
All right.
It
Shelby
ends with,
Smith case?
yes, ends with 967. It's at 10 a.m.
I got it. 967 at 10 a.m. Thank you.
That's also Mr. Horka's case.
All right. Did Mr. Horka go with Attorney Blaney?
No,
Is he still out here?
he's still on the screen here.
Okay. Cameras. Calling case 2238167. This is that Gerson, Gerson Seppin, Detroit Renaissance Fund LLC versus all occupants of 17420 Prairie Street, City of Detroit. We do have someone who has self-identified by the name of Shelby, Shelby Smith. Ms. Shelby Smith, unmute your microphone, state your full name for the record, please.
Shelby Smith.
Very well. Ms. Smith, are there any other adult occupants of the location of 17420 Prairie Street?
There is not.
Very well, thank you. Attorneys?
Good morning, Your Honor. Joe Horka, P75969 for plaintiff.
Mary Blaney, P72940 on behalf of Shelby Smith. And Your Honor, I'll be filing a notice of appearance on this case. Mr. Horka has worked with me on trying to secure an offer for Ms. Smith. Ms. Smith is not interested now in the property. The price is quite a lot higher than anticipated. We just agreed to the judgment and asked that the case remain with no occupants.
Very well. All right, so there would be a consent judgment by hearing against occupants.
Yes,
Judgment by hearing against occupants. Very well. The vacate date would be what, counsel?
10 days. Ms. Smith indicated to me that she does not have any personal property in the house. This is the case where another fraudulent conveyance where someone sold her the house after it already belonged to Detroit Renaissance Fund.
Wow.
I have a question, Your Honor, if I could ask it.
And you can ask, and if I can answer, I will. If I cannot, ma'am, I'll let you know that that's not something I have to do. I can do. I'll have to refer you back to the attorneys, but go ahead and ask the question.
Okay, not a problem. In regards to the tickets that I received, as well as the taxes and everything being in my name, how do I go about receiving that? Because I received like 3 tickets for the grass not being cut. And then I just received my summer taxes and I paid my winter taxes already. So.
Ms. Smith, I put that in the chat. You need to go to the city and go to the tax department, take a copy of the warranty deed that Mr. Horka showed proof that Detroit Renaissance Fund owned it, and take a copy of the judgment and show them that you had no ownership of the property.
Okay.
Any other questions, ma'am?
No, that's it.
Okay.
All right. All right. So, ma'am, you understand that this judgment against you is, well, it's not going to be against you. It's just going to be against occupants. So you're not going to have anything on your record that says you were evicted.
Okay.
And now, Miss Blaney, I don't know if there's anything you talked to Mr. Horka about, but in a situation like this where a person is a victim of fraud and we're still doing a judgment by hearing, this could not be a dismissal?
I would ask for a dismissal, but I wasn't sure what Mr. Horka might need. I assumed he'd want a judgment.
Yeah, conditional dismissal with box 4B checked is fine with us.
I'm sorry, I didn't understand you.
I had indicated a conditional dismissal with box 4B checked is acceptable.
Oh, all right. Well, then I take that back. If we could do that, then.
Yes. I think that would be more appropriate in a case where a person is a victim of fraud and not a person who just tried to take over some property. So, all right, a conditional dismissal.
Mr. Horka, will you be submitting that?
Yes, we will draft it and send it over to you for review.
All right, thank you.
All right, Ms. Smith, the deal has changed a little bit. It's now a dismissal. So there's not going to be any type of judgment that's going to be associated with you in any kind of way, be it a judgment against occupants or anything. It's just going to be a dismissal. Your name is not going to be associated with this property for any type of judgment in any kind of way. So, all right, ma'am, but you still have to be out of the property on or before August the 4th. You understand that?
I do.
All right, ma'am. If you're out of the property, make sure that the landlord has the keys, make sure that there's no trash or damage done to the property, and you'll have your dismissal, ma'am. Good luck to you.
Thank you.
Ms. Smith, you can email me if you have any questions.
Okay, thank you so much.
Your Honor, I'm also ready on the Markeisha Jones case, ending in 914.
Okay, 1 second. Four. I don't seem to have that case. Let's see. Oh, I do have it. My apologies. This is case number 22381914. This is J. James Investments, LLC versus occupants of, Markeisha Jones and all occupants of 15044 Prest, P-R-E-S-T. Markeisha Jones is M-A-K-E-S-H-A. Jones is common spelling. Appearances, please.
Good morning, Your Honor. Attorney John Gwynn, P43822 for the plaintiff.
Your Honor, I am not representing Ms. Jones. I was only looking into the case. I attempted to contact Mr. Attorney Anthony Green. I believe that, and I have not received a response. Mr. Green is only a part-time attorney with Lakeshore Legal Aid, and he may very well think that this has actually been set for tomorrow or for Friday, because the Tuesdays and Fridays are Lakeshore days. So I would ask that it be reset for tomorrow or for Friday.
All right, counsel.
Your Honor, I'm out of town Thursday and Fridays. That might be difficult for me. Can we set it out maybe a week or two?
No, I have no problem with that. Ms. Blaney, I did not realize that Mr. Green was part-time. So tell me what days and times he's here, and we can make sure that we don't do this again. So
Tuesdays and Fridays. I'm actually only part-time in theory.
But I see you. I must have a different definition of part-time. So
I'm a workaholic. Mr. Green and I are both here on Tuesdays and Fridays. So
all right, counsel. You said you're going to be out of town for how long, sir?
Just this Thursday and Friday, Your Honor, and then I'll be back.
Thank you, Mr. Attorney Quinn.
Madam Clerk, could you tell me what this coming Tuesday looks like if we can squeeze another one in? I don't want to put one in if we already have 60 cases on that day, Attorney Quinn.
I understand, Your Honor.
You have 39 cases.
Okay, we have 40, but we'll squeeze one more in, sir. One more in.
For tomorrow? Or for the following, or the second?
At a second.
Okay.
That'll be 10 a.m., Your Honor?
Yes, that'll be a good time, sir.
Okay, thank you, Judge.
Thank you.
Ms. Jones, I will inform Mr. Green and hopefully he will get back in contact with you shortly.
Judge, can I ask you a question, please?
Who are you, ma'am?
Makisha Jones. I'm sorry for
Yes,
the
ma'am.
record.
Yes, Miss Jones.
You had asked to send in the paperwork. I just want to affirm that you received it. I faxed it 7/15/2022, and then I also came down to the court on Thursday.
Okay, ma'am. I have a stack of about 300 files in front of me, so it may be in there, and I'll check it. But you got to let me get to that case.
Okay.
That's actually this case, Your Honor.
Yes.
That's this.
Yes.
All right. Well, ma'am, I will check
Friday.
for it. We're going to come back on Tuesday, August the 2nd at 10 a.m. So I should have everything in front of me then.
Your Honor, may I also ask that Ms. Jones forward a copy of whatever she filed with court to my office?
Actually, I would just ask that Ms. Jones forward it to us, and if Mr. Green is representing, then we'll forward it to you.
Okay, yeah, I just haven't received an appearance from him, so.
I understand. I'm gonna check into all of that. And Ms. Jones, you have Mr. Green's email address, correct?
No, ma'am. Can you give it to me? And I filed it at the court just to assure that the judge get it. He asked for proof of payment from 2016 till now. I filed it with the court clerk too. So I faxed it 7/15. I kept the confirmation.
Ma'am, I told you. I told you.
Okay. So, sorry.
I'm gonna drop it into the chat. I'm gonna give you both his and my email address.
Okay.
Okay.
Thank you.
All right. This matter is adjourned till August the 2nd, 2022 at 10 a.m.
Thank you, Your Honor.
Thank you.
Your Honor, Attorney Carey and I have a matter we're ready to go forward on.
All right, counsel, what do we need? What do we have?
9 o'clock matter ending in 200.
Calling case 22383200. Jonjonat, JOJONAT LLC versus John Doe and all other occupants of 16574 Ward Street, City of Detroit. We do have on an earlier date, I did have someone who self-identified as being an occupant. That person's name was Quinn, Quin Winston. Is there a Quinn Winston out here?
Yes. I pronounced Penn.
Penn Winston. All right, I heard it wrong last time. All right, Penn Winston. Okay, thank you, sir. Counsel?
For the record, Your Honor, Sharon Moore, P70411, Michigan Legal Services, here on behalf of the defendant.
And Matthew Carey, P81793, on behalf of the plaintiff.
Your Honor,
how are we going?
Parties have had an opportunity to talk, and we're going to enter into, I believe it's going to be a consent judgment against all occupants. Defendant agrees to move out by August 19th, 2022, and box 4B will be checked. So I guess, yeah.
Okay.
Is that
right.
correct, Attorney Carey?
That's correct.
Okay.
Yes.
All right, Mr. Winston?
Yes.
You had an opportunity to speak with an attorney in the breakout room, correct?
Yes.
And you've agreed that they're going to do a judgment against occupants. It's not going to have your name on it, so there will be no eviction on your record, your renting record, as a result of this case. You understand that?
Yes.
But you do have to be out of the property on or before August the 19th. You got that, sir?
Yes. August the 19th.
August the 19th. Oh, that's the last day that you can be there. So you understand, on August the 8th, August the 20th, on August the 20th, if you are not out of that property, they can ask for a judgment of the, a writ of eviction. And that would cause a court officer to come out. They can open the doors and they can remove all your property, put it in a dumpster, and you would be out of that property as a result of that. You understand that, sir?
Yes.
Okay. Just want you to understand that. Make sure, sir, that the landlord, or I don't know if you've been dealing with anybody, that if you don't know who to reach, you can look at your paperwork, maybe call the attorney's office. If you don't know who to turn the keys over to or who to turn the property over to, or someone to let them know that you have moved out on time, on or before August the 19th. You understand that, sir?
Yeah, I gotta let them know that.
Yes, sir. You can't just
Please
walk out
call
and
me.
leave and let somebody know that you're gone, sir.
You can give me a
You always
call,
got-
Mr. Winston.
All right. All right, Mr. Winston. Mr.
Yes.
Winston. All right. You received paperwork, a summons, right?
No,
You didn't receive something in the mail that said that you had to come to court?
no, I called the judge, which was you, and you gave me the information over the phone.
All right. So nothing was placed on your door or anything that gave you any type of notice?
No,
So you just decided to call to find out if you had a court date without any other reason to know that?
no, I was talking to an attorney 4 months ago, and I got disconnected. I called back the following day, and the judge told me to call back on the 7th month, on the 25th, on 9 o'clock.
Well, let me ask you this, sir. When you first talked to an attorney, what caused you to talk to an attorney?
Oh, because of the first case I had with y'all. The
All right.
phone number they gave me.
All right. The paperwork you have, it had a lawyer's name on it, correct?
Yes.
All right.
A lawyer name? Let me see.
Yes, sir.
Yeah, yes.
Lawyer, it says Matthew Carey.
Yes.
All right. If you can't reach anyone else, you call that number, let the attorney know that you have moved out of the property. And that way they know you moved out on or before August the 19th, sir.
Thank you.
All right. Good luck to you, sir.
Thank you.
Attorney Carey,
you,
I
Your Honor.
chatted you my email address so you can send the copy to me.
Hello?
Okay. Thank you.
Mr. Winston, you're free to disconnect.
Thank you.
Okay.
Judge
All
Wagner,
right. Okay, 1 second. Miss Makisha Jones.
Yes, sir.
Didn't we complete your case, ma'am?
No, I was told to wait to go in the breakout room so she could give me the judge's the attorney's email to forward the paper. She told me. So I haven't had an invitation to come into the breakout room yet, so I was waiting till I see it. pop
Okay.
up.
All right then, ma'am. Let's see, who spoke to you earlier? That was Miss Gibson.
Yes, Judge.
Is Miss Jones waiting for something from either you or the attorney?
She was waiting for a Lakeshore attorney because Miss Attorney Green isn't with United Community Housing Coalition. He's with Lakeshore.
Right. So
I wouldn't have
hold on 1
a
second.
Lakeshore attorney email address.
No, okay. Let me. Do we have? Did I give you that 914 file? It's not up here. No. Oh, I think I kept it here for a reason. I got it. Because I was going to be looking for it. All right, Miss Jones.
Yes, sir.
All right, you were the individual that told me that you had submitted some stuff and I needed to put it in the file, right?
Yes, 2 times.
Okay, no, I'm gonna get that and I'll have that back out here before we adjourn this matter until August the 2nd at 10 a.m. I'm gonna pull all the paperwork and that I might have it in the file already. I've got some stuff in here to sign. So we'll deal with all of that on August the 2nd at 10 a.m., ma'am.
Okay,
All right. Good luck to you. We'll see you then.
thank you. So wait, are they gonna give me the email number? So, cause the attorney said to forward it to her too. I got one packet, one I faxed and one I walked down to the court up to the 2nd floor and filed it with the clerk, and she's submitting it to you. She took everything and stamped it.
I will have it, ma'am.
Okay.
All right. We'll see you on August the 2nd, ma'am.
Okay. Can I get the
All right.
email, Judge? Can you tell them to give me the email, please, while we're on the record, and then I'll have it. She said.
What do you mean give you the email?
The attorney, when we were on the record, she asked me and Mr. John Glenn to forward the information and asked me, did I have Attorney Green email? I said no, and she was going to
I don't have Attorney Green's email, ma'am. I'll make sure anything he needs he gets though. All right.
All right.
I don't
Great.
have his. Okay. So
Thank you so much.
all right. Thank you.
Judge Wagner,
Yes, sir, Mr. Abbott.
Ms. Boyke and I have a case ready,
What case number is it, sir?
3651, 10 o'clock.
3651. I have it in hand. Calling case 22383651. This is Russell Management Company versus Patricia Sykes and Deontay Peterson and all occupants of 8410 Penrod Street, City of Detroit. Is there okay,
Yes,
go
I'm
ahead,
here.
counsel. Oh,
James
go ahead, Mr. Abbott.
James Evans appearing on behalf of the plaintiff P26085.
Please might you make sure we played. I'm here to talk about the defendant.
All right, Ms. Boyke, we're breaking up. We're breaking up, so
Can you hear me better?
a little bit. Yes, go ahead.
Elise Boyke on behalf of the defendant P84955.
All right, Ms. Boyke. Ms. Patricia Sykes or Deontay Peterson, unmute your microphone, state your full name.
Yes, this is Patricia Sykes.
Is there a Deontay Peterson or any other adults that's occupant of 8410 Penrod Street?
No, we don't live together no more.
All right. All right, now you place yourself on the record. The attorneys, how are we going to proceed?
We're going to seek a brief adjournment, Your Honor.
A brief adjournment, you said, sir?
Yes, I believe so.
All right. How much time do we need?
Please.
Should we say a week? Is that something you're good with, Attorney Abbott?
That's not going to work. We got to go out a little further than that. My docket is jammed up right through the next 2-3 weeks. So
I mean, we don't have a preference. We are just requesting a worksheet. It appears her Sarah application has been approved, so we are just in that process.
all right. Where are we in the process? Is that something that you think you can have that quick, counsel?
I suspect that should be pretty quick, Your Honor.
All right, if that's all we're doing, and if you have the worksheet, it's either are you expecting an approval that quickly? Because I can put something in if you think that that's going to happen. If that's just going to be a dismissal for Sarah for payments or the acceptance in the program.
So it looks like it's been approved. We're just confirming the amount that has been approved to see if we can get this, this resolved.
All right, we can do this quickly then. How about All right. How about, what day do you need, counsel?
I can come in any day, but I'm typically in the court Tuesday, Friday,
What days are you normally here?
Tuesdays and Fridays.
All right. All right. How about, I believe this is going to be quick. So how about August the 5th? It's a Friday.
Your Honor. What time?
9 a.m.
Thank you, Your Honor.
All right, Mr. Abbott, that good with you?
Good with me.
All right. All right. This matter is adjourned to August the 5th, 2022 at 9 a.m.
Okay, thank you.
Thank you.
Thank you, Your Honor. Thank you, Attorney Abbott. Have a good one.
Elise.
Good morning, Mr. Dodd. How are you today?
Good morning, Judge. I am excellent. And yourself?
I am well. I am well. I don't see your name on my docket. Do you have,
I'm actually, yes, we do have a matter. It is a 10 o'clock matter, Your Honor, for Callahan.
Ms.
And
Callahan. I don't,
Yeah, I believe Attorney Moore was helping out with this one.
on 394?
Yes.
Ending in 394? I have not seen a Zsa Zsa Hubbard, but let me see if I am wrong. Maybe Ms. Moore will have more information on that, but I'm going into the breakout rooms to see if there's a Ms. Zsa Zsa Hubbard out here. So I don't see it. And, well, I don't see a defendant there. Is there anyone in the courtroom that, well, let me take a quick look at this. 914. 394. Is there anyone in the courtroom that is an occupant on 16137 Prevost Street, City of Detroit? All right, Mr. Dad, I don't believe that there is going, I think this is, wait a minute. We were last here on July the 11th, 2022. There was a CR application that was being processed through Wayne Metro. We adjourned today, and this was just to be a control date. Do you believe, has a dismissal, conditional dismissal been entered on this? Because it looks like it's that type of case.
No, Your Honor. So we, Wayne Metro claims that that Sarah paid to September 2022. However, we did receive approval. We just have not received payment yet on this one. So I don't know if it's better to adjourn this on a Wayne Metro, on a Lakeshore Legal Aid Day, or I'm not sure as to what, I do realize that with Wayne Metro, these payments can take quite some time, but that is the update that we have.
All right, well, we can adjourn it to a Lakeshore Day. And because today was just to be a control date anyway, so let's see what their payments were.
Your Honor.
Yes.
Okay. Ms. Hubbard, I had spoken with Ms. Hubbard and we were working on her case, and I provided information because the application was done with Wayne Metro. I didn't try to get it transferred over to UCHC, but we can follow up. I don't know that transferring this to a Lakeshore Day is going to move things any faster. And it may provide a little bit of confusion. So if we could just adjourn it to another UCHC day.
All right, well, as long as, I just got the impression when I spoke with counsel that someone from Lakeshore may have looked at this already. So, but if in fact you're willing to take it, then Attorney Haddad has already said there has been an approval. She just doesn't know how much money it is right now. So, we'll just, how much time do you think it'll be? 1 week, counsel, that we need to follow up on this?
Unfortunately, Your Honor, no.
You don't know.
That is the question.
And to keep the process moving, let's do I'd say let's do 3 weeks to the 15th, Your Honor. I mean, obviously, if it comes through before then, we'll send all the documents and get everything resolved before then.
The week of the 15th is not a good week at all.
Oh, that's right, Your Honor. Well, we can set it for like the 8th or the 11th. Oh, but I know the 11th has a lot on it already.
Yeah, but you know what? I sometimes make exceptions for cases that we expect to be just confirmation of what we think is going to happen, like they've been accepted by Sarah. It's just, you're going to submit are you okay, Ms. Moore?
Yeah, I'm okay. Thanks, Your Honor.
Okay. All right. You had a facial expression that made me believe you were in some distress. So
I'm okay. Thank you, Your Honor.
okay. All right. All right. So why don't we do how about we do Thursday, the August 11th.
Okay.
Madam Clerk tells me I did not call the case. So Madam Court Reporter, I should say. This is case number 223813994. This is plaintiff is 19303 Monte Vista LLC. Defendant is Jaja ZSA Hubbard, and all occupants of 16137 Prevost, City of Detroit. This matter is being adjourned until August the 11th at 9 a.m.
Thank you, Your Honor.
Thank you, Judge, and thank you, Ms. Moore.
Thank you.
Let me ask Court Reporter one last thing. Madam Court Reporter, although we were talking on the record, but kind of off the record because I hadn't called the case, do you need the attorneys to do an appearance on it now? That would be nice. Yes, please, attorney's appearance, please.
Good morning, Judge Rania Haddad, P84927 on behalf of the plaintiff.
Good morning, Sharon Moore, P70411 Michigan Legal Services on behalf of the defendant.
Very well. This matter is adjourned until August the 11th at Thursday, August 11th at 9 a.m.
Thank you, Judge.
Thank you.
Thank you, Ms. Haddad. We'll be in touch. Oh, she's gone. Okay.
Judge Wagner, this is Lamb. I'm prepared for a matter when you are ready.
Okay. You know, Mr. Lamb, you have this very unique, not quite, but almost James Earl Jones voice. But when you say almost every single time, come on, this is Michael Lane. I really do know who you are when you start talking, sir. Not quite James Earl Jones, but it's still pretty cool. So what do you have, sir?
I appreciate that. I'll cease with the introductions moving forward. Okay, I have a matter ending in 581, scheduled at 10 a.m.
581, yes, sir. I don't know if you recognize this, but it looks like I only have maybe 2, 3 other cases for today that would involve any of you. So
I have recognized that, and I am excited about it.
Well, you don't see what I'm doing to contain my excitement, but so almost jumping up and down and spinning around in circles or something. This is case number 223833581. This is Mr. Eric Davis, plaintiff, versus Lewis Davis and Tiana Moore, and all occupants of 14774 Wilfred Street, upper unit.
Yes, Eric Davis for the plaintiff.
All right, thank you. Good morning to you, Mr. Davis.
Good morning.
Is there a Lewis Davis and a Tiana Moore, or anyone who's an occupant of the address of 14774 Wilfred Street, upper unit, in the courtroom?
Lewis Davis here.
All right, Mr. Davis. Is there Tiana Moore here, or any other adult occupants for that address?
No, she's not present.
Very well. All right. Counsel?
Good morning, Your Honor. My name is Michael Lamb. My P number is 79816. Your Honor, I had the opportunity to speak to Mr. Davis, Mr. Lewis Davis, concerning this matter. I've also had the opportunity to review the summons and complaint. As such, Your Honor, I am respectfully requesting that this matter be dismissed for two reasons. One, I understand that plaintiff, Mr. Eric Davis, is operating as Davis Properties LLC, and today he is here representing himself, which is not allowed. He is supposed to have legal counsel. Secondly, Your Honor, that my client he has a valid lease with the landlord. And in the complaint, there was no valid reason provided in which to terminate the lease between the parties. And for those two reasons, I am respectfully requesting that this matter be dismissed.
All right. Mr. Davis, let me ask you a couple of questions.
Yes.
By what method were you terminating this lease, sir?
We are terminating for cause under lease violations. At the last hearing, this was already discussed, and Your Honor ordered parties to, there's an issue of excessive damage, meter manipulation, and you stipulated at the last hearing, if we could prove meter manipulation, we would be having a immediate eviction on this case due to the.
Did you submit some documents or pictures or anything, sir?
Yes. So what we've done is at the last hearing, Mr. Lewis Davis was represented by Ms. Valerie Moran, who we have been sending the stuff to. She has not provided us anything to counter the evidence that we sent her. What we have sent her is the referral from DTE showing the meter manipulation on multiple accounts. We've also sent her the police report on March 2nd from Detroit Police coming out and investigating the illegal wiretap and the theft of the power. We have sent her pictures from the city inspector showing that when he went into the unit, showing the excessive damage to the property. And we've sent her kind of just a dialogue of what has happened. This has been a continuing matter of.
Who did you send this information to, sir?
We sent it to her within, started the very next day from the court hearing. So
who did you send it to, sir? Who?
Oh,
whom?
Valerie, and then it's Moran. She was the attorney last hearing.
Okay.
Your Honor, I'm attempting to reach Attorney Moran to see if I can get her to appear. If you could pass this matter for a moment, I'll see that I can get her into the courtroom today. If you give me a moment, Your Honor.
Your Honor, one more thing.
Yes, sir.
I did get an email from Valerie Moran. It was on Friday, late Friday, showing that she filed for a subpoena on DTE. They've had 11 days to investigate this. They waited until Friday to even do a subpoena to get the referral. They've waited too long. We're asking the court to enter.
Okay, hold on, sir. Hold on. We're trying to get that attorney in the courtroom, and then you can make that argument in front of somebody who was a part of it. So hold on.
Your Honor, if I may.
Yes.
I was able to reach Attorney Moran. She asked, she was confused. She thought that this was not, that this case was adjourned to another date. She's asking if the court would pass this matter and give her about 10 minutes. She will
Oh, no
appear.
problem.
Okay.
No problem. Thank you.
Sure. Thank you, Your Honor.
We'll recall this case when the attorney appears. Attorney Moran, you're here.
Yes, Your Honor. I apologize. I had this scheduled for the 28th. Your Honor, adjourned for discovery, and I did in fact send out a subpoena to the utility company in question, and I have not received a response back yet on that. I also copied Mr. Davis on the email when I sent it out.
Right, Mr. Davis says he sent you a copy of all those things that you were requesting.
No, he sent me several emails, but he also stated that he was not sure of the account number even. I reached
All right,
out.
let me recall the case while you're here so we can have this all on record. This is
Certainly.
case number 22383581. Again, this is Eric Davis, who has already placed his name on the record, versus Lewis Davis and Tiana Moore and all occupants of 14774 Wilfred Street, upper unit. The defendants are represented by counsel. Your name and P number again, please.
Good morning, Your Honor. Attorney Valerie Moran, 498 Michigan Legal Services.
Mr. Davis?
Yes, sir.
All right, just state your name again for the record, sir.
Oh, yes. Eric Davis for the plaintiff.
All right, Mr. Eric Davis,
Yes.
would you put on the record what you sent to counsel or what you say you sent to counsel?
We sent the referral number for DTE and also what we believe the account number is. Every account number that we have starts with 9200. We couldn't find the full account number because they don't give you the full one in any email. It's not showing up under the profile anymore because we believe that they've deactivated access due to the meter manipulation because they flagged the account. So
what did you have to show that meter was manipulated?
So we sent referral number for when we called DTE.
Okay, let me stop you for a second, sir. When you say we, who are you referring to?
Me and my wife.
All right, well, right now, you're the only one on record. Just state what you did, sir. And if you did it with your wife, you still did it.
Yeah. So I did the referral and we've done multiple referrals. That was the last one and the most current. And we sent the account number. Along with that, we've sent a notarized letter from a worker that worked on the unit right before Mr. Lewis Davis moved in, and he stipulated the condition of the unit when Mr. Lewis moved in. There's a City of Detroit police report on March 2nd for illegal wiretap and drilling through the side of the house to run extension cords. We sent pictures from the city inspector that just went out showing water leaking from the upstairs into the downstairs unit, along with ceiling damage. And there's looks like black mold growing in the kitchen cabinet due to water leaking. I think I said it all.
You said something about a police report earlier, about a police report for the utility theft?
Yes, so on a March 2nd, we called Detroit police out to the property. This was after the initial meter manipulation referral. They came out and they did a police report, and we provided that to council.
Okay, what address or email address did you send that to, or did you do it by fax?
We sent it to the one that she emailed me from. If you want, I can pull up the.
Okay. Counsel, did you receive anything from Mr. Eric Davis?
I did receive some pictures, Your Honor, that he said were of a city inspection. He did not provide the name or any information of the city inspector, no contact information whatsoever. I had inquired and asked for the account number for DTE. I did not receive that. He sent me, I guess, some documents over the weekend, Judge, but I am only part-time with Michigan Legal Services, and I am not working today. I'm scheduled to work on Wednesday. I did, while I was waiting, I just looked, and apparently he did send an email to the Michigan Legal Services email address on Saturday. I have not reviewed those yet, nor have I received back the subpoena that I sent out to DTE. As I stated, I had this case up for Wednesday.
Okay, well, I had it scheduled for today. I got my hand notes in the file that says
Yeah.
7/25, and that's the same date that Mr. Davis heard, because that's why he's here. So,
Well,
so
like I said, Your Honor, I'm not sure what happened. I'm flying without my legal assistant in this courtroom also. So I don't know. It's possible that when I was writing in the flurry of the day, I wrote down an 8 and it looked like a 5 to me. I don't know what to say, Judge. I do my best.
well, I understand anyone can make a mistake. I've done that before, been in the wrong place at the right time, or right place at the wrong time, or whatever. Wrong place having the wrong time. So, all right, I understand that, counsel, but we got to move forward on this.
Well, Your
The
Honor,
plaintiff is indicating that, no, I mean, very shortly is what I'm saying. I'm not going to leave you blind with there, but it's got to move very, very quickly. We have to do something in the next 2 days or so, because if what Mr. Davis is saying is true, we're going to move forward on this. And if there's manipulation, if there's problems, he's going to have to go.
Your Honor.
well, Your Honor, I did not let any grass grow under my feet. The exact same day we were in court previously, I reached out to our director, Mr. Phillips, and inquired who in our office regularly works with the utility companies. I also reached out to legal counsel Leland Price at DTE. He was not even sure who to serve a subpoena on. Back to me a few days later with that information, and I did send out a subpoena and I copied Eric Davis on it, and I'm waiting for that back. I also am reaching out. I reached out to an attorney that was in Judge Brew's courtroom when the first order was apparently put on the record, but not committed to a writing thereafter. I am happy to follow up with Judge Brew's clerk again. I don't know if that was intentional or an oversight due to just the crazy schedule that we're all in post-COVID. So, you know, I think I've done everything I can do as fast as it can be done.
So what are you proposing, counsel?
Well, Your Honor, I would like to adjourn until I can get the documentation back from DTE, which I hope is later this week. I'm happy to send them a follow-up email and ask for an ETA on their response to the subpoena.
And what do you have, Mr. Davis? What do you have?
So my thing is this, is they had.
No. Answer my question, sir. What do you have?
On, as far as what?
As far as documentation from DTE?
We don't have anything from DTE because they said that it would require a subpoena, which we haven't gone to get. We do have the police report. We have pictures.
And what type of pictures do you have?
We have taken pictures when Mr. Lewis Davis took the meter out, showing that there's no power to the meter at all. It's just sitting there. And then pictures after DTE placed the meter back and put a lock on the box, on the meter box, so that he couldn't take it out anymore. But we've got a Detroit Police Department report saying that they came out, there was drilling in the side of the house. I mean, we have documentation, excessive documentation to support this. They didn't do their subpoena until Friday at 4:26 p.m. They've had 11 days. They waited to do the subpoena. We asked that this this go forth.
Your Honor, as I just stated, as an officer of the court, I did not quote unquote wait to do this subpoena. I reached out to DTE the same day. I reached out to my director. Actually, now that I'm recalling, I also reached out to Bill Howlbauer. I reached out to my fellow counsel in the chat. There's a record of that. And as soon as I received the information of where I could send a subpoena to, as we all know, departments are working remotely due to COVID, I immediately sent it out.
Yeah.
So
All
for
right.
him to say I quote unquote waited when I did all of that as part-time contract
He's
counsel, I
based
think it's
on,
a gross.
he's looking, well, he looks at what he sees and he draws his conclusion. That's okay, counsel.
And then there's the
I don't
reality,
take,
Your Honor.
I don't take that as you've done something that you've slept on or anything and waited. Sometimes things take time. Yes, I understand that. Now, the question is, I'm gonna ask some other questions that I'm concerned about. Mr. Davis, when was the last time you received any rent?
We have not received rent since October of 2021.
Of 2021. Okay.
And also utilities too. We have.
All right. Let me ask Mr. Where is he? I don't see the defendant out here anymore. Mr. Lewis Davis. Oh, when's the last time you paid rent?
October, November.
Why?
This is the reason he started the case. I was short on rent 1 month. He said you have until Friday to get it to me. I didn't get paid till Tuesday. I didn't have the money.
And I talked about October. What has happened? What happened in November, December, January, February, March, April, May? What happened then?
He was starting this case. He didn't want no money from me. He told me he wasn't going to take
Because he wants you out of the property. You haven't paid any rent. Why should you stay there another day, sir?
Okay.
Tell me a good reason you should be allowed to stay in that property another day.
Excuse me, Your Honor. I'm going to politely and respectfully state that I believe Mr. Davis stated that the landlord would not accept rent. So I don't think he can hold him down and physically demand that he take rent. I believe that was his statement, to Your Honor.
Hold on, because I don't have a notice to quit or anything in here. Mr. Davis, did you refuse to take any rent?
No, we and actually, contrary to what counsel said, in all of my leases has a Cash App name that he could have sent money to, and he had sent money to me on Cash App previously. So,
all right, did you tell him at any time you were not going to accept any money?
No.
Okay. All right. So, Mr. Davis, you said he told you he wasn't going to take any money from you?
Yes, he said you still gonna have to pay me when I sue you in court. He said, and then after that, we went to
wait a minute. He said he wasn't going to accept any money, but you're going to have to pay me when I sue you in court. So he's saying he did want money.
At that time, that's what he told me. And then
okay, sir. What you're saying doesn't make sense to me, sir.
And then in
all right.
Your Honor.
Yes, counsel. Yes, counsel. Stop, Mr. Davis. Your attorney is talking. Go ahead, counsel.
Your Honor, I'm going to respectfully ask that you please allow Mr. Davis to finish, and then perhaps it would make sense.
Okay. All right. Mr. Davis, if I cut you off and you wanted something else to say that was going to make sense, please go forward. Go ahead.
All I was saying was after we went to court with Judge Brew, my attorney then told me not that I don't pay him no rent.
And when did you go to court with Judge Brew?
It started in February.
All right. So, but you stopped paying in October, right?
Yes. He told me he wasn't going to take rent from me.
All right. Well, you just said that they said that in front of Judge Brew.
Yeah, they said in front of, that's what he told me in front of Judge Brew too.
Hey, but that was February. And at that point, you already had not paid for like 5 months, correct?
Yep.
Yeah, okay.
Your Honor.
Yes.
So I have never said that I wouldn't take rent, and the only thing that happened in Judge Brew's court was the case was dismissed on a technicality because I did not put my filing that there was a lease violation. At no point was it ever brought up or said or mentioned that I refused rent. I have never refused rent from any tenant. I would have loved to have the money that he owes me, but I don't have it. So it's going to cost me.
So let me ask you a question, Mr. Eric Davis.
Yes.
Who was the electric bill's name be in? Would it be in your name as a landlord, or would it be in the tenant's name?
So originally it was in Mr. Lewis Davis's name. He found out that that in the house, one of the circuits also goes to the downstairs unit, only one of them.
Okay.
So,
all right.
And so I put in my name, but it was in his lease that he paid utilities. He was supposed to pay me for the utilities. And then because he didn't ever pay utilities, it got disconnected. Also, Judge, I sent.
So it got disconnected when?
I'll have to pull the email, but I sent counsel the emails from DTE showing that it was disconnected by DTE for non-payment.
All right, I get that. I get that. So when did that happen?
Give me 1 second here, Your Honor, and I'll pull that up. That was February 16th. I got the email from DTE showing that it was disconnected for non-payment.
February 16th of 2022, correct? February 16th, 2022?
Yes,
Did you ever pay that? Did you ever pay the bill to have the electricity reconnected?
Yes, we paid over $300 when we were in Judge Brew's court, and we thought that the power was turned on. And then DTE told us after we found out it still wasn't on, that they weren't going to turn it on until the tenant paid the fine for the meter manipulation.
Okay. Do you have something from DTE that says that?
I have a start order email, which I sent counsel, that we tried to turn the service back on and they canceled the order. That was in April.
Does it say the reason the order was canceled on the documents that you have?
It says because documentation was not turned in, and that documentation was the fine being paid. They wanted the fine paid and the lease sent in. And we sent the lease in, but the fine was never paid because the tenant refused to pay it.
Okay.
Well, Your Honor, I didn't want to interrupt Mr. Davis, but obviously I object to all of this, I guess, quasi testimony coming on the record that's like hearsay. And it appears he's testifying and he was never sworn in. And I'm trying to find the documents that he alleges he sent to me. And I do not recall seeing anything that stated anything about conclusions that DTE came to. I did see a request to restart service, but it was not until April, which is troubling since Judge Brew had ordered it to be restored in March. And I realize, Your Honor, it didn't, as near as I've been able to investigate so far, get reduced to a written order. I'm still trying to get a definitive response on that.
On what? On what? A written order for what? I'm sorry, counsel, a written order for what?
To restore the electrical service.
So you said Judge Brew did not do it. And quite frankly, counsel, even if Judge Brew ordered it, you know, that is still placing the onus on the landlord when he's saying that it was disconnected because of actions of your client. So.
Well, that's what he's saying, Your Honor. But with all due respect, Judge Brew obviously I'm told by other counsel found it to be a little bit different, which is why, as I stated, I'm told by.
I don't think anything is obvious, counsel. I don't, without a transcript, so.
Well,
I don't think anything is, because I've seen judges order people to do stuff, and from what he's saying, he did that because he said he asked for it to be reconnected, and he got a letter back from DTE saying they wouldn't do it because of issues. So
I guess,
if there's
Your
some
Honor,
type of legal, pardon me?
I guess, Your Honor, I think it would be a fair question to ask why, if a judge ordered on the record on, I believe it was March 8th, but I'd have to double check, that the power be restored. I think it's a fair question as to why no request was made according to the documentation I have received until April. You know,
well, even if it was April, he did it, and they were told that they couldn't do it or they wouldn't do it. So I don't know what the delay was. I don't know. I don't know either, counsel.
Your Honor. I don't know, Your Honor, that is what DTE actually stated. Like I said, I have a subpoena outstanding where I requested information as to what happened with that account, what the status was, when there were requests, etc. I believe it's been submitted to the court. I did also serve it on Mr. Davis.
Your Honor.
Yes.
It is customary with DTE, if your service is disconnected for non-payment and you pay the full balance, we did, it automatically is reconnected. It's automatically done. I don't have to do a request to turn on service because it's not actually disconnected for a period of time. Okay, we paid the balance on March 18th as directed on a verbal order, not a written order, by Judge Brew. We did it, even though there was no actual order, okay, because I took her verbal order as a direction that she gave me, so I did it, okay? It is not our fault that DTE refused to do it because of an action caused by the tenant. We did our job as a landlord. I did everything I could do to turn it back on, even though legally he was required to pay utilities. Legally, I didn't have a legal obligation per the lease to pay his utilities. I did it because a judge, which I state that was not a legal order to order me to do it based upon the lease, because it was his obligation to pay the utilities, but I did it. So we did not interfere, have not interfered, and done everything we could do to get it turned back on.
Well, Your Honor, I again object to all of the hearsay and this quasi
Also,
testimony.
both sides are talking hearsay right now. You're saying hearsay, he's saying hearsay. So this is.
I just put an objection on the record, Your Honor. I'm not sure how that's remotely hearsay.
Well, no, when you talked about what occurred and what he did, you weren't there. You wouldn't have known that. You got that information from your client. So that would be the same thing.
What I relayed to this honorable court is that I had spoken with prior counsel on the status of an order, because I have not been able to yet locate a written order. And the information that I have thus far is that perhaps the written order was not actually done. And I suspect that somehow it slipped through the cracks, as I mentioned earlier, due to how busy courts have been due to
There's no
COVID.
question. There's no question. Well, you know, they're busy for a lot of reasons. We have a lot of people doing things in court, but they're busy. There is no question about that, counsel. There is no question. My question is, your client has indicated that for months he hadn't paid. If he hadn't paid his rent, I have no reason to believe he would be paying utilities. The utilities were disconnected. He indicated that. So the question
my client
is,
indicated, Your Honor, that the landlord refused to accept rent. I believe that was
right. But the question was, when did he start not accepting rent? He already indicated when he answered my questions that the landlord stopped accepting rent. It was months after he had not paid any rent. So
I would ask Your Honor that we clarify that because that is not my recollection of what.
Well,
Mr. Lewis
let's ask
had
your client
stated.
again, counsel. Let's ask your client again.
Yeah,
Mr.
thank
Davis,
you.
when did you tell me you stopped paying rent?
October, November.
You said October 1st, sir. Now you're
Yeah.
changing to November. So,
No,
so
Your Honor,
when did the landlord?
earlier.
No, he
Your
said
Honor,
October earlier.
No, Your Honor, he said the exact same thing, October,
No, he didn't,
November.
counsel. He said October
I said
earlier. He
October,
said
November.
October.
I said no,
All right.
both times.
Oh, so what does October, November mean? So what month did you stop paying? You stopped paying in 2 months or 1 month? When was the first time you stopped paying rent?
That's saying I have to go back and see because I don't remember exactly which month it was, but it was one of those
Oh,
months.
you don't remember? All right, sir. You don't remember. So sometime October, November, one of those months. Is that what you're saying?
Yes.
Okay. And when did the landlord tell you he wasn't taking your rent?
Be when he filed the claim from Judge Brew Court. Because he
And
told me
when was that?
that was in February.
All right. All right.
They the reason I haven't paid electricity was because like he said, the half of the power is on the units is switched up where half of the power working upstairs, half power downstairs. So he put it in his name and me and the downstairs tenant was supposed to split it, but he never came to me and told me how much my electric bill was. We have one hot water tank, one furnace, so we got to split the gas.
We're talking about electricity right now, sir. We're not talking, that gas has not been raised at this point. So,
okay.
so he didn't come and tell you how much money you owed for electricity. Is that what you're telling me?
Yes.
So, and you didn't split it with the other tenant like you did with your gas.
That's what we were supposed to do for both of them. He never told me the price on either one.
Oh, okay. All right. All right.
Your Honor, if I may.
Yes, sir.
Mr. Lewis Davis had the electricity in his name until the end of October. It was switched to my name starting in probably the 10th of November time. I had texted him, but he paid up through October. November is when we started to have issues. He didn't move in until September 1st. This is a very short time that he gave me any money for anything. And I never at any time refused any money. So,
all right. So the electric bill was in your name for a while, Mr. Davis?
Yes, I was excited about moving in. I haven't even seen the basement. I went in the basement and noticed I was paying for both gas meters, and I called him and told him, and he said he'll switch it to this name and he'll tell us how much we paid.
that was not
all right. Yeah, I understand. So,
Well, Your
yes,
Honor, I
counsel.
believe, I believe there is a question on whether or not this property is appropriately divided into 2 units.
Well, counsel, there's a lot of apartments or 2-family flats in the city of Detroit where there is 1 meter, and that is normally divided between the tenants. So that's just the way the properties are. So.
Well, and there are a lot of properties, Your Honor, that are rented out, that are not certified, that are not inspected, and that
Are
don't
you
get
saying this
things done
property was not?
correctly.
Are you saying that this property was not certified, counsel?
I'm trying to look that up right now, Your Honor. Like I said, I
Okay.
had this on my
So-
calendar for the 28th. That's my recollection, but I have a lot of cases and I don't trust my memory.
if I,
Okay.
Your Honor.
Yes, counsel. Yes, sir.
This property is not at this time have a certificate of compliance. There's an issue with getting the deed recorded because of COVID. And we were not able to do that until spring of this year. For that reason, it's not done, but I've been working with the city about getting it registered and passing all the inspections, but that in itself would not stop the tenant from being evicted.
I understand, sir. I recognize what's necessary, what's done, but you show something, you have some documentation that you've been working with the city to get whatever needs to be to get compliance. Is that what you're saying?
Yes, yes. We have
What do you have?
We have talked to them about getting it registered. We had got an account on the ELAPS website, and we're going to be going through that. The problem is that we can't do the city inspections because Mr. Lewis Davis is not a tenant we can work with. So we can't have the city go in there and do their inspection and go through the process that we need to go through to get it registered. So that's the biggest problem right now.
Well, Your Honor, Mr. Davis just testified that Mr. Lewis Davis didn't move in until September. So I'm not sure what his excuse was before that. Additionally, Your Honor, I had some
Counsel, hold on, counsel. First of all, to say what his excuse was, we don't even know if he had that property before that. So, you know, just to make a comment like that is not fair. To say we don't know what his excuse was before that. You don't know. Have you asked when he bought the property, or he became a landlord, or he decided to rent the property out?
Actually, Your Honor, I looked that up at the last court hearing, and I found a land contract, but not a deed. And I had a very animated discussion with Mr. Eric Davis, where he voiced to me very exuberantly that a land contract was. I explained to him that it was not. A land contract was a land contract and a deed was a deed. And at that point, he disconnected the Zoom. And then he stated that he didn't have to talk to me.
All right. Well, technically he doesn't. So
you're right, Judge. He sure doesn't.
So in any event, what we're going to do, we're going to get a short adjournment. And if there is evidence that there's been manipulation, meters have changed, entered, or manipulated in any form or fashion, this is going to be a very, very quick and easy decision for me. If that has not occurred, then it'll be a bit more difficult, and it'll be a lot more factually based, whatever it might be. Yes, counsel?
Yes, Judge. I would like to order a transcript, and I'm not sure how much time Madam Court Reporter needs.
I don't know. How quickly could you get a transcript, Madam Court Reporter? 2 weeks. But we're going to do this. I'm not going to wait 2 weeks to continue with this case, counsel.
Understood.
Because yes,
are you on?
Because I'm a little animated because I find it sometimes, you know, I like to be fair to both sides, and sometimes I'll be hard on the plaintiffs and landlords, and sometimes I'll be hard on defendants. But I've had a number of cases where there was some type of destruction to the property, and the case went on and on and on and on. And I think that's very, very unfair to the landlords. If I see the landlord doing something that is unfair to the defendants, I will be very, very difficult and hard on them. So
that is true, Judge. I've been in front of you on cases where, in fact, you were hard on the landlord. That is true. However, you know, as I'm sure Your Honor also understands and respects, I have to do my job, and that includes.
So I have no problem with you. Even if you're very animated with me, I love zealous advocacy. I think you are doing the right thing, and I will never hold it against an attorney for disagreeing with me or fighting with me or getting loud with me. You know, we would do that, but I believe that's what's necessary in zealous advocacy.
Well,
Pardon me?
I said I try never to get loud, Your Honor. I don't like to see counsel, that in the courtroom, but I do try to advocate zealously.
Okay. Well, let me say this, counsel. I don't necessarily see loud as anything but your passion. Okay. And I would appreciate it more if you get loud and voice your opinion and do what you have to do if you think you are in the right. So I have no problem with that. I don't, sometimes I get a little loud, you know, or speaking quickly anyway, at the very least. And I know that sometimes the attorneys look like, and you might feel like I'm being unfair to you, but as you said, you've seen me do it with both sides, because I take every case individually. And what I've done on any other case doesn't cross over. So,
No, and
and-
I
and-
appreciate that, Judge. It's just very difficult during these times because if I had my way, I'd have this stuff on my desk instantaneously. And,
I-
you know, I'm in a situation where I have to have an opportunity to do my job. And, you know, I'm still trying to get documentation together. And it
Right.
has not been for a want of trying. I can assure this court of that.
Oh, I recognize that, counsel. Like I said, in the time frame that we have worked together, I would never ever consider that you have done something that was shirking your responsibility or delaying. You do
Well,
what
thank
you're
you,
supposed to
Judge.
do, and I expect that, and I respect that. I sometimes get a little agitated when someone's property is maybe being damaged, or and I don't even get as agitated when there's just a period of time or months when a person has not received their money. I get much more agitated when I think that their property might be damaged or something like that, and because I've seen a number of cases like that, as you have. And then those are the cases that I want to make sure, if in fact that is happening, that that person is no longer in that property where they can continue to do damage. I actually was contacted earlier today about a case, and the plaintiff was calling, and he was asking about a order for the eviction, and indicated that the person came back and burned the property down. So that's
Well, I've been doing this 25 years, Judge, and there, you know, I think any attorney or judge that's been at this a while has an extreme story like that.
Oh, we all do.
Fortunately,
We all
are
do.
very much out of the norm.
I agree with that, but what I just indicated was the extreme. There is no question of that. But I think we've all seen something of a lesser standard. We've seen windows broken out, or we've seen something like that, or some type of retaliation, or trashing a place when they moved out.
I
But
also, Your Honor, have personally been involved in cases where the landlord themselves vandalized the property and then tried to pin it on tenants. So unfortunately, bad behavior and illegal conduct cuts both ways.
you know what? That's human nature, counsel. I don't believe your position makes you right by virtue of your position.
I'm just
So-
saying there are people on both sides of the fence that are doing things they should not
I-
be doing on a regular
agree.
basis.
I agree. And that's why I said I take every case individually. But sometimes when I see something that makes me believe, even though I may not have, we have not gotten to the final decision. And sometimes you've probably seen me get a little agitated like this and then turn around at the end of the case and do something that was exactly what the defense attorney was asking for. So, but as I flesh things out, you know, sometimes I do get a little agitated. So.
I have a
But
question, Your
I know.
Honor. Can Mr. Davis please provide to me and I guess this court, the name of the city inspector or inspectors he says he's been working with? Because I did not see any name or contact information at all in any of the information.
Mr. Davis.
Yes, so two things. One is, at the last hearing, Mr. Lewis Davis brought up an inspection from the city that he was going to submit, which I didn't get. That has the inspector's name on it, number one, but I can provide the phone number for the inspector that called me, because I did not get papers. I got a phone call from the city inspector to ask questions about what was going on.
All right.
Well, actually, Your Honor, earlier he placed on this record that he had gotten photographs from that inspector. So I'm not sure how he got those photographs unless they were somehow sent to him. It seems odd he would have had photographs but no name.
Okay, I got pictures through a text. I don't recall his name, but I would really like you to not keep on misconstruing what I'm saying.
Hold on. Sir, don't, you know what? Don't take it personal. She's saying that you got a text. So it is a logical conclusion that there would have been a name. Now, if you don't remember it, that's a totally different thing. So And you just said you don't remember it, but you do have the information and you do have the telephone number. Is that correct?
Yes, I have the phone number.
Okay, and you can provide that, you can provide that to council. Could you, council, can you provide him with your email? Sir, are you gonna send this by fax or email?
I will probably do a screenshot with my phone and email it to her, just so she
Okay.
has a written record of it.
Thank you. I appreciate that, sir. It's the same email as before. Do you need it again, or do you still have it on your system?
I have it in my email.
Great. Thank you, Judge.
All right, all right. Ms. Moran, is there anything that you have that you could provide to Mr. Davis? And you know what, Mr. Davis, I'm gonna ask you to send this by, if you can, send a fax to the court as well. I'm gonna give you a fax number.
All right.
Fax number is 313-967-7551. All right. All right. And Mr. Davis, you may not understand this, but discovery, this is discovery. That's when you provide whatever information you have to the other side. That's reciprocal. That means if she has anything, she'll have to send it to you as well and to the court.
Yes, Judge. Yep. As soon as I receive a response from the subpoena, Mr. Davis, I will forward it to you.
So, Judge,
Yes.
a big thing here is this, is that a subpoena can take 30 days for them to comply. Pushing this out, we have documented lease violations. Is there a reason why we can't just do a 10-day order?
Well, a couple of reasons, sir. I don't have that. And does the defense attorney have it?
For the lease violations?
I don't know what you've given her, sir.
So what? Well, we've given her the evidence.
No. Let me say this, sir. When you say lease violations, is there anything that is documented? So, in other words, if you say what, by example, sir, what lease violation are you talking about?
So, first of all, he's got people not on the lease living in the unit and has been, and we're talking up to possibly 10 people is what I'm told.
Now, okay, here's my question to you, sir. Did you ever give him notice of that?
We sent him a text with it and also a letter way back when we first came.
All right. That's what you have to do, sir. You provide that to the court. You provide that to defense counsel as well. Those are the things. You tell us something, sir. If you don't provide documentation, you don't, there's nothing to back that up, sir. That is why you have documentation. So if you come out here and tell us, well, this is what happened, you need to provide the documentation, sir. If the defense attorney has it, that's something that she can check out. And they could check whatever. If something comes out of it, fine. If not, then that's what it is. But you have to give notice to the other side of all that you have and the reason that you're doing it. Because if you just say it happened, they can say it didn't happen. If you had a conversation with the person, you send them text messages, then that is something that is solid and provable that there was conversation going back and forth, and you can't say what you didn't say, and they can't say what they didn't say because it is a document. All right. And one of the greatest things about emails now is you don't get to manipulate who you send it to or who it goes to or what time it was sent or what day it was sent. You have that. You can say on this date, I sent this message and here's a copy of it. That's what makes your case strong or weak, sir. You know, right now, all I have is what you say and what the other person says. So those things have to be submitted. And then I can look at it and I can say, I have evidence that everything that you said is true or not. So those are the things that are needed, sir. Unfortunately, we're at a point where the defense counsel, unfortunately for you, sir, as to what you want to do today, and I'm not saying it's unfortunate that this is a final decision, but the defense attorney has the right, the authority, and it is necessary that they investigate everything that you've said, investigate everything her client has said, and find the truth out of it all. Because this is a courtroom, sir, of truth and justice, and we can't just go by. And sometimes, you know, if there is no truth, in fact, when I mean something that is documented, and then the truth just has to I have to make a determination as to what person A is saying versus what person B is saying, and this court has to look at it and see what makes sense and make a decision. If in fact you provided me with all the things that I need to make a decision, that evidence is making a decision, and it's not something that's just based on a person's reactions or who comes across in a fashion that is believable or something like that, or just because somebody might be more eloquent and articulate than someone else, which might sway anyone because we are all human beings. But if you have something that is documented, you have photographs, you have conversation going back and forth that is documented in emails or text messages, that is what's going to be the strength of the case, sir. So you got a police report saying they came out there, then that's going to be strong. It's not just you saying something. If you got something from DTE, a letter that says that there's been manipulation or theft of energy, then that's going to be strong. So and right now, the defense attorney has a duty, an obligation, and she's held to that. It's a very high standard. That's why she is an attorney and she is licensed by the state of Michigan, and she has to do things in a certain way. So things that she asked for, sir, it might rub you as being, you know, an irritant, but that is her job and that's her responsibility, and she does it well. So, I have to adjourn for that matter. You have to give us what you have. She has to get what she can get from an independent source, the city of Detroit. And when we get it all together, it very well may be a very clear picture, one way or the other. Which I don't get to make that decision until we get there. So, all right. So I do have to adjourn it for a period of time. I'm going to try to adjourn it to the least amount of time as possible. You said the subpoena takes 30 days. It very well may not take that because she's already requested the subpoena. She's not just doing a request today. She's already done it. So the question is, how quickly will it be returned to her? All right, Attorney Moran, when do you think we can get back to this as quickly as possible?
You know, I will state, Your Honor, that in my middle section of the subpoena, I did put an asterisk and I asked them to return it to us as soon as possible because of the short adjournment date. So I would suspect it would be less than 30 days. I cannot guarantee anything.
I know it's outside your control, counsel, but
yeah,
but you put the request in and you did ask for it to be expedited.
I did, Your Honor. And,
right.
You know, that was, I'm not sure what I could do beyond that. And Your Honor earlier had stated there was a question about when Mr. Lewis acquired the property. As I stated, Your Honor, at the first court hearing, I did pull this from the Register of Deeds, and it was on a land contract, and it states that it was entered into on the 21st day of October of the year 2020. And I would assume that Mr. Lewis got possession of the property at the time he entered into the land contract.
Okay. That's a reasonable assumption. So that's when he became legally responsible for it. So
according to the Wayne County Register of Deeds, yes, Judge.
All right. All right, Mr. Davis, I apologize to you that this is going to go on a little bit longer. I have to keep catching myself because your name is Davis and defendant's name is Davis, and I have to stop and say, am I saying the right name, and look down at the file again to make sure that I'm talking to the right person. So, Mr. Eric Davis, I understand that you wanted some type of resolution today. Unfortunately, justice doesn't happen as quickly as we all want it to do. Want it sometimes. Sometimes it's faster. Sometimes we got to get documents. Sometimes we have to go through bureaucracies that take a little bit longer than we want them to. So we're going to try to do this as quickly as possible, sir. I don't want any delays. I think, but I can't guarantee that all the things are going to be back. What I'm going to do is I'm going to try to put a earlier control date out there. Where I'm going to schedule it with the hope and anticipation that we'll have it that day, but the caveat will be if we don't have everything on that day, we might have to put another date out there a little bit further out. But I'm going to schedule a quicker date, hoping that we'll have everything. So I'm going to put a date out there now of Attorney Moran, you need a Tuesday, Friday, right?
No, Your Honor, either typically a Wednesday or a Thursday is best for me.
Okay, because sometimes I get confused with the various legal agencies out here and what their dates are. I know UCHC is Monday, Wednesday, Thursday, but you're not that, and you're Michigan Legal Services, correct?
Correct, but typically you see me on Wednesdays or Thursdays.
Okay, all right, then that's what I'm gonna do. We're gonna look at let's try August the 10th.
All right, thank you, Judge.
It scares me saying that because I really believe that date is going to be pretty heavy, but okay, but we're going to try it on August the 10th at 9 a.m.
Judge, if I may.
Yes, sir.
One thing, Mr. Lewis Davis has stipulated that he's not using to pay rent. So can we ask him to put so much money in escrow to be held by the court?
Actually, at this point, did you file a notice? This wasn't a notice to quit, was it? This was just for a lease violation.
This is for termination of tenancy under multiple lease violations.
Well, Your Honor, I would object. I believe the file is deficient for him to make that request and make it at this time.
He has caused excessive damage to the property. We're extending this beyond a reasonable amount of time for, I mean, we request that there be.
Well, actually, sir, you don't have an attorney, do you, sir?
No.
Because I just asked you, did you do a notice to quit? And you said no, but I do have a notice to quit in the file.
Well,
that's it.
30-day notice. So I was thinking of a non-payment of rent. This is done under the 30-day notice, termination of tenancy.
All right. You know what? I can't give legal advice, Mr. Davis, but the legal advice I'm going to give you does not refer to this case. The legal advice that I'm going to give you, sir, is you should have an attorney. I don't know if you have any other rental properties or any other rental agreements with anyone, but you might want to talk to an attorney, at least for even if you don't have them on retainer, if you just do it by need. Maybe you need to talk to an attorney whenever you do something like this, because if you decide to do it on your own and it's not up to snuff per se, then there's nothing that says, well, we give him a break because he's not an attorney. You either have to educate yourself on getting all your paperwork right, or you have to consult with an attorney, sir. Because I see it every day. Cases get dismissed because someone didn't check the right box, or they didn't put the right date on it. They didn't do something like that. And that's the legal advice I give. If you endeavor into a business that there's a lot of scrutiny of, you need to maybe consult with an attorney before you submit your paperwork, sir. Because when counsel came out and she said, I have reasons to dismiss this case for several things, you need to make sure that if your paperwork is right, because there's attorneys on the other side, and you don't, that's life, sir. You might have to consult with an attorney before you do your paperwork from this day going forward. So in any event, this matter is adjourned until August the 10th at 9 a.m.
Thank you, Your Honor. And may I also reach out to Lewis Davis? Mr. Davis, I'd like to speak with you in a breakout room before you hang up, please.
Okay.
Okay, and Your Honor, I do not have breakout room privileges since
That's
since
because
I
she
thought I
just
was
popped
not
in.
working today.
Yeah, and all right, you have it now, counsel. All right. All right. All right. The attorneys on our case for attorney Richardville and attorney Ladas. I see you're both here. You're timely, of course. Again, I'm not, but we will get with you out. The court reporter has to take a 15-minute break. So again, more delays for you. I'm glad I'm not getting billed by the hour.
No worries, Judge. Thank you.
As you can see, this courtroom is this is the lightest day I've seen, and I mean I'm actually done with my regular docket. The lightest day I've seen in months. I normally
That's quite the achievement these days.
Yeah, it is. Mr. Richardville, I have to ask, what is that behind you on your photograph on your wall?
Oh, so that is it's an official seal for the state of Michigan.
Okay.
I had worked for the Michigan State Senate. Gosh.
Okay.
And
That,
so
I recognize. So
what's that?
yeah, I recognize it was something along that nature. So that's why I'm seeing
it's
what award have you
signed by the
received?
head of the four chambers at that time, which
Okay.
I hate to say it, but one of the Senate Majority Leader at the time was Randy Richardville. That's basically how I got it. And Governor
Okay.
Snyder's on there, and then
so that Randy Richardville, that's no relation, right? So
yeah, we're
I know.
related. Not my dad, but he's my second cousin. My dad's first
Okay.
cousin.
All right. Is your dad a lawyer as well?
No, nope. But my dad's in nuclear energy. He's way smarter.
Oh.
Retired already.
Yeah.
Smarter in career path.
Any job that you're smart enough to retire early in life,
Yeah.
It's the ones that we keep working and working into our 70s or no 70s. I'm way past that. I'm getting real close to 80 now. So
yeah, it's
maybe I need to start talking about retirement, counsel. Attorney Moore. It's going to be that time.
Hey, I think when you desire it and you think it's appropriate, Judge, then it's appropriate.
But see, that problem is everyone thinks it's appropriate when they think it's appropriate. But when people retire, it's like when my dad retired. He said, if I had known it was going to be like this, I would have did this a long time ago. So we all have this anticipation, like, well, all of a sudden, I'm going to have a little less money every month, and I'm going to do this, and I got to keep working just in case. And then when people retire, they're like, why didn't I do this earlier? So
fear is a very, very powerful motivator, and it motivates people to make choices that I think would, in the long run, are against their best interest. So
yeah, sometimes that's like, I heard of
not having enough money, fear of whatever. It's a very powerful motivator. It keeps people from doing certain things.
Yeah, I know. I just heard that Marvin Barnett died. So he's an attorney, longtime attorney.
Wow.
And working. People say, well, when are you going to retire? It's like, just so.
Maybe he. My hope is that he enjoyed doing the work up until he stopped doing it.
Yeah.
So that is
like Bob Mitchell. So. Yeah. No, I want to retire to my home in Florida, but I wanted to say my beach home in Florida, but it's not a beach home. It does have a pool, but a beach home would be a lot nicer.
Given what I've heard about the weather, maybe staying a little ways away from the beach is not such a bad idea.
He'll have beachfront property in a couple of years, so who knows?
Oh, no, let's not say that, let's not say that. I was in New Orleans shortly before Katrina. I actually evacuated out. So, big water coming in land is not a pretty thing. So,
Oh my goodness. That's scary. That's very scary.
I was actually there working with the Marine Corps. And so, we got orders, everybody get out of Dodge,
Sure.
So it's probably maybe 5-6 days before it actually hit. And left all our gear and everything there, and we couldn't get back in. So they sent us overseas and just shipped us in all new gear, all new uniforms and boots and everything. So,
Wow.
Your Honor, I believe that all the cases for UCHC and MLS have been adjudicated today. So
yes, that is correct.
I'm going to step away. However, Ms. Gibson, I think, is going to be here for this case. If anybody else shows up.
No, this is the last. No, we have nothing else. I have a case between two private attorneys. So it's actually really a civil case. But so.
Ms. Gibson do not need to stay.
No, you do not need to stay, Ms. Gibson. You don't have to smile so largely. So you just want to leave me now.
Delighted, delighted beyond belief.
No, you guys are wonderful. So no, we're all done with all of your cases for today.
Okay, Your Honor. Then I am going to leave. If for any reason the court needs me, please don't hesitate to just call me back.
I won't. All right.
All right. I'll see you on Wednesday, Judge. Have
See
a
you
good day.
Wednesday.
Be safe. Be safe. Court reporter be back anyway. She's been working straight through since 8:30 and this would normally be her time for a lunch break, but I didn't even give her a break during the day. Sometimes I think I'm a very bad person. So
Not a problem. I'm going to step away just for a moment.
is that a smile coming on your face? Are you were doing this, but it looked like a half smile was coming on your face.
Oh,
Yeah. It's something good coming. Did you have to get your port? Did you get your port? Your port. Port.
oh, it's Thursday.
All right, gentlemen. We are, if Mr. Ladas is here, we're back on the record we're calling case 223811903. This is Value Save Property LLC, Michigan Limited Liability Corporation versus Value Save Inc., a Michigan corporation, and all occupants. Now, appearance, please.
Good afternoon, Your Honor. Ryan Richardsville, P77335 on behalf of the plaintiff.
Good afternoon, Your Honor. May it please the court, Eric Ladaz, P65354 on behalf of defendants.
All right, I do have a question right off the bat. Value Save Property LLC versus Value Save Inc. I believe it was Mr. Rubenstein, attorney for Value Save Property, wrote that there was a search of Lara for the entity of Value Save Property Holding Company, LLC, and there showed there to be no such entity. Is that correct?
That he wrote that, or that there isn't?
No, this is in one of the pleadings on the June 3rd. Plaintiff's response and brief to defendant's motion to dismiss and for court cost and sanctions. And basically they're saying that there is no standing because the business is not registered with Lara because it is not an actual LLC.
I can address that issue, Your Honor, if I may.
Yes.
Thank you. The original lease was entered into in 2002. It was discovered in late 2005 that the original landlord, the party you just named, never was formed, which would have been Value Save Property Holding Company, LLC. When that discovery was made in 2005, there was an amendment to the lease. The amendment is my Exhibit C to my reply.
Okay. Let's see, your reply was dated
June 7th.
June 7th. Okay. And so the lease was amended, correct?
3 times, correct.
All right. And that amendment did what? Change the name of the company?
It recognized that Value Save Property Holding Company, LLC was incorrectly defined as the landlord's name. And the real name should have been Value Save Real Property Holdings Company, a Michigan co-partnership. So the amendment to the lease dated January 5th, 2006 changes the name of the landlord, nunc pro tunc, meaning back to the commencement of the original lease, to name Value Save Real Property Holding Company, a Michigan co-partnership, as the original landlord. It was signed off on by both the landlord and the tenant on January 5th, 2006. So that issue was corrected in 2006.
Attorney Richardville?
Judge, there's the issue is the standing for the Third Amendment. We discussed the Second Amendment, and the standing goes to the person who signed, Eddie Barash, on behalf of Value Save Property LLC, did not have the authority at this time to bind my client because in 2018 there was that membership interest purchase agreement where an individual named Wissam Satam bought 60% of the outstanding membership, becoming the majority member of Value Save Property LLC. Now, the argument has been that he didn't do it appropriately, or however that argument went. I won't speak for counsel, but there's a couple issues with that, Your Honor. One, this was made 3 years after Mr. Satam had already become a member. Now, the members to Value Safe Property LLC are Barash Yusuf Holdings and my client. Eddie Barash was a 50% shareholder at this time in 2018. The acceptance of the membership on the membership purchase agreement should be undisputed because 50%, a member with 50% authority signed on behalf of them. You see that Raid Yusuf signature on there. And in 2019, that Yusuf then gifted or transferred his membership interest to Eddie Barash in 2019 for Barash Yusuf Holdings. So even still, not only did he, we didn't need both signatures for the membership interest purchase agreement. And in 2021, there is no standing for Mr. Barash to sign on behalf of Value Safe Property LLC, because even if he had all the authority, Barash Yusuf Holdings isn't a 40% member, or is only a 40% member, and it would need the majority to vote. So in either event, this third amendment is not valid, and that's the reason we're seeking the eviction.
Your Honor, may I respond to that point?
Absolutely.
If that third amendment to lease was never executed, you still have an original lease that runs through 2032. If this third amendment to lease never existed, then you still have another 10 years of tenancy left. I can get into why this amendment is valid.
If that amendment is never recognized, then you go back to the earlier, because if I'm reading this rightly or reading what you're saying correctly, the amendment is what makes it a value or a valid document, because the earlier use of a name that was not an actual corporation. So actually help me to understand this. If in fact you're saying the third amendment fixed the corporation and allowing it to have standing, but now we are not going to use it for.
No, Your Honor. No.
Okay.
No. The second amendment changed the name in 2006.
Okay, the second amendment, not the third.
The third amendment was July 27, 2021, which extended the term from 2032 for an additional 10 terms. So the third amendment only extends the original lease. So even if this court did not recognize the third amendment to the lease, you still have a valid lease agreement between the parties through 2032. But my argument still is that the third amendment to the lease is valid. Mr. Barash was the manager of Value Safe Property LLC on July 27, 2021, which Mr. Satam, the purported purchaser of an interest of Value Safe Property LLC, admits because Mr. Satam's attorney wrote a letter on August 20th, 2021, attempting to remove Eddie Barash as manager a month after the third amendment to lease.
But wasn't that request based on his position as a member and not a person with the authority to, let's see, where is it? Well, go ahead. You finish, and I'll let the attorneys talk, and I'll reserve my questions. So.
Okay. I just want to make sure that I don't know if Mr. Richardville is confusing the terms member and manager, because you have both member managed LLCs and you also have manager managed LLCs. Eddie Barash is not an owner directly of Value Safe Property LLC. Barash Yusuf Holdings LLC is a 40% owner of Value Safe Property, which Eddie Barash is 100% owner of that entity. Nonetheless, for decades, Eddie Barash has been the manager of Value Safe Property LLC, all the way through August 20th of 2021. That is undisputed. It was Wissam Satam's attorney on August 20th of 2021, after the third amendment to the lease, is when they attempted to remove Eddie Barash as manager. By sending that letter, they admit prior to August 20th, 2021, Eddie Barash has been the manager, duly authorized to act on behalf of Value Safe Property LLC. Now, we dispute that Mr. Satam is.
You said he was the manager duly authorized. Isn't that what's in contention?
No, the duly authorized is in the actual operating agreement for Value Safe Property LLC. It names Eddie Barash as the manager. So Value Safe Property LLC authorized Eddie Barash to be the manager to act on its behalf.
All right.
That authority continued even on July 27th, 2021, when Eddie Barash executed the third amendment to the lease. But again, Your Honor, going back, even without this third amendment, which I think is a red herring, you still have an original lease that runs through 2032. And there's no allegations of any violations of that original lease. They claim the name was incorrect, but in 2006 that was corrected. And there's nothing else that they have alleged or put in any pleading of a lease violation of the original lease.
Well, the lease isn't through 2032. It's a series of shorter leases that will arrive at 2032. And often people do that because that gives them an opportunity to break the lease, because it's a renewable lease as opposed to a standard lease that goes through 2032, correct?
Correct. There are 5 successive 5-year options to renew for that, which
and Judge, this is
they have been exercised.
Sorry.
No problem, Ryan. Yeah, and they all have been exercised.
So, Judge, I think the language there is, kind of telling what this case is. Eddie Barash signed a 50-year extension that his company will get paid by his other company and continue them. I mean, this is what this is for. They say it will be because they know it will be, because it doesn't actually have to go through a renewal. It's just, this one individual is trying to, I guess, usurp, corporate powers. And to the member or manager issue, the Wissam Satam, I mean, just the title of the document, it's the membership interest purchase agreement. So if he was only going to be some qualified purchaser, I would think that it would be a qualified purchasing agreement as opposed to a membership interest. If you're entering into a membership interest purchase agreement and not buying a membership, I think there's something seriously wrong, or some wrongdoing afoot.
And Your Honor, I know you've made the comments that why isn't this in circuit court? Well, it is. It's in 2 separate Oakland County Circuit Court actions, which are both pending right now.
Right.
And the reason that it's in Oakland County is that all the parties are Oakland County residents.
Yes.
This isn't a quiet title case. This is about the rights and determinations and the management abilities of Value Safe Property LLC. Then it goes to where all the parties reside, which is in Oakland County.
Yeah, I get that. So it's still 2 Oakland County cases?
Yes.
And the issue of, now, I guess I don't understand why there's 2 Oakland County cases. There's a separate issue in each one of those cases?
Yes, Your Honor. Without getting into all the other claims that do not relate to this, the original Oakland County case that was filed in 2021, there's one cause of action that it's for Value Save Inc., the grocery store. And it was a declaratory action to see if Wissam Satam had the authority to issue a notice to quit for the property. However, Value Safe Property LLC is not a party to that original case. So when this eviction was filed, Value Safe Property LLC filed a 2022 action in Oakland County both Value Safe Property LLC and Barish Use of Holdings LLC and Eddie Barish against Wissam Satam, and it's 3 counts of declaratory relief to seek who are the owners and what are their rights, who's the manager, and if Wissam Satam was not able to be the manager, then void out any of his actions. That's the new case. It is very limited to that determination of the rights of the parties of Value Safe Property LLC. And that case is what is going to determine really would be the outcome of this case.
Yeah, and it's plaintiff's position that the declaratory action that was just described, the 2022 case, was filed as a defense, obviously, to this eviction. And the cases were attempted to be consolidated by Mr. Barash's, I guess, I don't know what side it is because we're talking to 3 cases, but the judge denied, we opposed consolidating these, and the judge denied their request to do so.
Your Honor, this is just one piece of 6 separate lawsuits so far. And Your Honor, I don't know if this has been brought up to you or not, but Wissam Satam claims to buy 60% of Value Safe Property LLC. Value Safe Inc., the grocery store that's the tenant, is owned 51% by Eddie Barash, 49% Wissam Satam. They have multiple business interests that this is basically one gigantic business divorce case. Mr. Barash caught Mr. Satam stealing money from the grocery store, which is what sparked the original 2021 lawsuit, which is now morphed into 6 separate lawsuits.
And we claim it's the opposite, so.
That's the nature of lawsuits, right?
Yeah, exactly. I mean, clearly.
Okay.
Look at that very, I appreciate the court not laughing at that very intellectual comment I just made there.
No. This is just not my normal termination of tenancy because, because it goes so much more into corporate structure and members and buyers and managers and things of that nature, as opposed to a mom and pop landlord owner. And but what causes me to take so much time with this, which is probably not enough, because again, I have to educate myself in areas of law that I not really don't really practice. But if I were to, and this is just a hypothetical, if I were to rule in the plaintiff's favor, how does that affect the corporate dealings with respect to the what's happening in? It's not going to affect what's going to happen in Oakland County because they're going to do their rulings for period. But I'm trying to look at this in a fashion that I do the right thing, and just wonder how it's going to downstream with is it going to have any impact at all with regard to what Oakland County is going to do?
Your Honor, in essence, if you were to grant the plaintiff relief, you would be evicting a grocery store that's been in business for decades, which is the subject of the original Oakland County litigation.
Right.
But and Your Honor, I guess it's
Oh, you're starting to break up now,
if you're
Attorney
talking about
Richardson.
in terms of, I'm saying if you are talking technically, if you were to grant us, deny this motion, I don't think anything negative would come of it, or that's entirely dispositive would come of denying a motion to dismiss. I feel like we would just move to the hearing stage of the eviction.
Yeah.
But Your Honor, I have not heard from Mr. Richardville what allegation, if any, is there a violation of the original lease that allows Value Save Inc. to occupy the premises?
I actually did have the little note here that I was going to ask that very question. So, because I see a lot of things. I was looking for the very, very specific language as to what the violation was. And actually, what the, first of all, is the lease valid? And then if the lease is valid, what is the violation? So.
Your Honor, I believe I'm going to rely on our pleadings. I'm looking for the original complaint. I believe this was filed, you know, on the main purpose that the, you know, before we had no knowledge of the purported Second Amendment. We only had the original lease, which has been admitted that that entity was not even an entity. That's the information that we had at the time it was filed. I don't believe a supplemental complaint was ever filed. And as you had indicated earlier, my supervisor, Mr. Rubenstein, did file that.
Yeah.
Your Honor, the original complaint only cites the reason was tenancy was terminated by notice to quit. And in the notice to quit, the only thing is checked is the box that says MCL 554.1341 or 3, which is the tenant at sufferance. There's no
tenant what?
Tenant at sufferance, meaning a holdover tenant.
Yeah.
There's no allegations of a lease violation and there's no supplemental complaint. The only thing they argued in their response is that there's no standing because of the issue of the original name of the landlord, but that issue was corrected in 2006. Leaving no violation of a lease agreement that's currently in good standing by all parties.
Mr. Richardville, what is the specific violation?
Your Honor, I guess I have to rely on the pleadings. As I sit here right now, I do not know. And I don't mean I don't know. I cannot find my.
Oh, I get it. It's
because I personally didn't initiate it. I was handed the file and it's just stuck with me since the first day.
Okay, well, then I'm going to make this easy for us. I want you to hold on one second. All right. Counsel, I just need and if you want to take time to do it now, take a 10-15 minute break and come back and tell me what the very specific violation of the agreement is. We can do it now. If you need a few days to do it, I can. I think whenever we come back, this is something that shouldn't take more than 10 minutes because I've got an understanding now of what's going on. I just need to know if you filed indicating that there was a violation of the agreement. and you point that out to me, and we make a determination if there actually is a violation there. And I make my ruling right then, if in fact there is a violation. I understand it's a lot explaining the relationships, but I do need to get very, very pointed with if there is an actual violation of the
Your Honor,
agreement.
because, just because of my afternoon schedule, I would like an adjourn date if that's agreeable.
That is agreeable
Your Honor.
to me.
Sorry, go ahead.
But, and I can give you a quick turnaround, what was that? This is like next week.
Your Honor, this was again started by a notice to quit. And then in the
Yes, I
complaint,
understand.
only references the notice to quit. And I don't think it would be fair for us to come back on another day and then have an allegation that has not been brought up in their complaint. And then I have to try to respond on the fly without submitting any type of response, anything whatsoever, when on the face of their complaint.
I wouldn't do that to you, counsel. If in fact there is something that you could not have anticipated, I would not do that. The only way I can rule very, in your favor or against you is if they're pointing to something in the rental agreement that says that they've complied with or it's been violated.
Your Honor, that would
gonna be-
require a new notice to quit identifying that, giving my client 30 days to respond or cure such defect.
Well, I guess that would.
Filing of a complaint.
Yeah, I guess that would, because if it's not in the complaint now, the person does have time to hear and understand and respond to what the violation is, because counsel, I don't know what it is. And you indicated earlier that there was this was put together by someone else, and I don't know if he's Mr. Rubenstein is supervising or supervising attorney at the firm, or he is your boss, or whatever his title might be. Maybe he needs to respond to that question.
Yeah, and he's both, Your Honor. I mean, he's the owner.
Pardon me?
He's the owner and
Yeah.
my supervisor.
I know Rubenstein's firm has been around for a long time, so I didn't know if he was still active or if it was just his name on the letterhead these days, or.
Nope, still active.
All right. Well, if this is his pleadings, maybe he could say exactly what the violation is, because I kind of was searching, and I got stuck. Well, not stuck, but I did not realize that one of the amendments had corrected the actual party, and so that was done. But now I do need to know what the very, very specific violation is that would warrant eviction.
But Your Honor, that would require them starting over, not just making the allegation when we're now into our fourth or fifth court appearance on a complaint that does not set forth any allegation.
So your position is, if it's not very specifically articulated, then all of their whole pleadings fail.
Correct. That's thus the reason for filing my motion originally, Judge.
Okay.
And
counsel, you want to take a quick look and see, and then if you state something different than what's in here, then obviously counsel has a point. And if it's in here and I'm just not seeing it, then if you point that out to me, then counsel is on notice as to what your position is as to the violation.
Judge, at this time, I don't have that ability, but I'm going to just again rely on the pleadings in this, and just if I may add that even if everything is true, we don't know. There's an issue of fact as to whether the Second Amendment one was valid, and if the Third Amendment that was just signed is also valid. So I don't believe this operates to dismiss the entirety of the eviction based on that purpose.
But if the eviction is based on a violation of the contract, So you're saying that irrespective if there's a violation of the contract, there's other things here that would, I don't know how that I can do that. I don't.
Judge, I would just say there's an issue of fact as to whether that is true or not, and this would be more ripe for a hearing, or at least an evidentiary hearing for all the parties who are involved, especially in the membership interest purchase agreement, the all these other documents that go along with this, and some more
Okay, let me
required
see.
testimony.
All right, let me see something. Find me first. So let me ask a question. I'm looking at the complaint to recover possession of property and the notice to quit. The notice to quit says on February 11th of 2022, I served this motion on Value Save Inc. care of Eddie Barash. With the notice to quit, you're obviously just giving the person a time frame, telling them that you are asking them to vacate the property. And then the complaint to recover possession of property, which gives a little more detail into what or normally does, gives a little more detail into the reason for the notice to quit. The notice to quit can obviously just be for if the time frame has expired and you don't intend to extend the lease or something of that nature. In this case, it just says tenancy was terminated by notice to quit. Notice to quit in a case like this, this was on 4/12/22. At what stage was this, these multiple mini leases at this time on April 12th? I mean, was it at the conclusion of one of the renewable leases, or was it mid-lease or, because I don't know the dates of the many renewable leases that would take you out to 50 years or whatever it is.
The anniversary date is January 21st, Your Honor.
Okay.
In 5-year increments.
So
just
April the
recently.
12th would be not at a time where a lease was expiring, because the notice to quit said that the must vacate the property by March 13th of 2022, correct?
Correct.
But if there's a renewable lease, it would have to have something with a bit more detail. Generally, we see these, if we're dealing with property, once the lease has expired and it's gone to a finite period of time, like month to month or something like that. In this case, the finite time would be every 5 years or whatever time that lease would expire, correct?
Correct, Your Honor, and it is 5 years.
So the notice to quit would have to correspond to something, because it would have to be some other issues, a violation of the lease or something of that nature, to do it something outside of that 5-year renewable period.
Oh, yes, Your Honor, and moreover, it's at the tenant's sole option to extend. The landlord does not have the control over it.
Oh, it's the tenant's sole option. Okay.
Correct.
So, counsel,
Your Honor, remember
go ahead.
Sorry. This tenant didn't exist. If we're talking about the original lease, the tenant didn't exist. So the tenant doesn't have.
Value Safe Inc. has always existed. There's no allegation that Value Safe Inc. didn't exist.
Well, I'm sorry, Value Safe Property, whatever the property holding company was at the time.
Original landlord.
Yes.
Let's see. Yeah, this says Value Save Inc. So at this time, this actually did exist.
Value Safe Inc. has always existed, yes, Your Honor.
Yeah. Value Save, I'm sorry. Yeah. I don't think I said Value City because that's just a commercial that I see all the time or something. So value saving. So do we have a consensus that this is Value Save Property LLC, Value Save Inc., and occupants at the time that this summons was served, was that is two bona fide entities?
Yes.
Yes, but Value Save Inc. was in the original lease, Your Honor. Value Save Inc. is named as a successor
Value Save,
to the
you're doing it like
non-existing tenant or the non-existing company.
No, I think Mr. Richardville got it backwards. Value Safe Inc., the tenant, has always existed.
Yes.
The issue is with the original landlord, Value Save which the original landlord was called Value Save Property Holding Company LLC. And the issue was the LLC documentation never went in 2002. The issue was identified in 2005, where they made an amendment to the lease dated January 5th, 2006, correcting the issue, naming the proper landlord, which is Value Save Real Property Holding Company, a Michigan co-partnership, which has always been validly in existence when it transferred ownership to the current Value Save Property LLC.
Okay. So I come back to what is it about this notice to quit that was issued prior to the terminate or the end of one of the extendable leases? What and I don't see anything in the document other than the fact that there was a notice to quit, which I don't know that that's valid with the timing, because again, those renewable leases, is this in mid 5-year contract, March 13th of 2022? I don't know when this one started. So unless there is a reason other than I have the right to not, and your client wouldn't have that right, counsel, to not extend the lease, because if that ability only extends to the defendant, I would have to see something in this in this summons that says property is being, or the contract is not being renewed for a reason. And I don't see any, there's no notice in here for what reason other than they're asking for a notice to quit.
Judge, at the time when this was filed, and up and until I believe it was June 7th when defendant filed their reply brief, this second lease issue, the second amendment to the lease, no, we had no knowledge of it on our side. So at the outset, I believe our theory was this company, the landlord who entered into this lease was non-existent. Therefore, they only have, none of the terms or the rental periods matter because that company wasn't in existence, and we had no knowledge of that until, and so as we filed, we stated, okay, this is a tenancy at sufferance because there's, you know, their only relationship is based on how they're acting, and they get paid every month, so that's why they were provided a month's notice.
But wasn't that issue? Okay, I'm not going to ask question. Counsel, Attorney Ladas.
Your Honor, Mr. Richardville said they didn't have the second amendment to the lease. Well, it was provided to them on June 7th, and I have not heard any argument to the contrary that.
7th of what year? June 7th of what year?
No, I said the second amendment to the lease was provided to Mr. Richardville in my reply on June 7th, and I haven't seen.
Of what year? I just need the year on the record.
Oh, right now in the pleading in this court, 22.
Okay, all right.
And I have not received anything from Mr. Richardville questioning anything about this document other than it corrects the issue that they set forth as their legal basis to bring this eviction action.
And Your Honor, this wasn't in the original motion to dismiss. I responded and then we got it. You know, I'm not allowed to file a reply to a reply per the court rules.
Well, I'm still kind of hung up on the Tennessee was terminated by notice to quit without any kind of detail as to you have the right to do a notice to quit anytime that there is not an active contract or active lease agreement. And if it's at the end, and that's what I'm saying, I'm not hearing anything that says that with these multiple extendable leases. So I got a lease through this to 5 years from now, then I could get a new one from this to another 5 years. Is it not, unless there is something that is in direct violation of the use of the property in between those 5 years, can you just ask for a notice to quit then, or do you have to wait until that 5 years and say, you know, even if you have the right to do it, I don't know the way the contract was formulated and written. If in fact I have a 5-year lease that is renewable. If I'm into year 3, can you serve a notice to quit on me and not a termination of tenancy with reasons?
Yes, because you are a non-existent entity and you cannot enter into a contract.
Which was rectified.
The person who entered into the entity that entered into it was not in existence. And
okay, but they were in existence at this time because there had been an amendment at that point. Is that correct, to correct it?
Yes, it is. That's correct, Judge.
So if that had been corrected prior to 2022, this year, then that's not a valid argument because maybe they didn't exist at the time of the contract, which was amended and ratified and whatever, and now that becomes the new agreement, contractually speaking, for a 5-year period. That's the way I see it. Am I not stating that correctly?
You're correct, Your Honor.
And to break that lease, you would have to have something that the other party has done that violates the contract, because even though at some period of time that that entity did not exist. And once it was addressed and amended and all parties agreed to it, then today, then that is a valid organization, entity that you'll have to comply with all terms and conditions and evict based on a violation of the contract. And I don't see anything that says, it just says notice to quit. I need to see that there is a reason that the person is not allowed to go forward with additional, like, I don't know, you opened up a dispensary in the store as well, or some sort, marijuana. And so now that is in a conflict with the use agreement that this is going to be a grocery store and not a marijuana dispensary. And so now we're going to say, I'm going to serve a termination of tenancy for these reasons. This does not comport with the agreement that I made that this was going to be a community grocery store. It is now a community grocery store / marijuana dispensary. And I would see why you could do that and break the agreement. If you didn't have something like that, you could wait till to the conclusion of one of those mini contracts and say, we choose not to continue with this relationship. And I'll have to do a survey notice to quit timely on that, but I don't know how we do it interim. And the whole purpose and reason is to break up this 50-year agreement into shorter agreements, because you can make a determination that the person is not in compliance or their actions don't comport, or I just want to end the relationship because we've designed it in such a way that I don't really have to give you anything if I just don't have to act in a fashion that's going to allow us to go to the next 5-year agreement. There would be no reason to break those up if you just say, hey, this is really a 50-year agreement, or however long the entire agreement was, if you add all of the shorter agreements involved to take it out to. Maybe I'm confused, but I don't see any reason to do it that way other than things in the world change. That is no longer a good place for a supermarket because the community has changed and whatever reasons. As opposed to, I got a 50-year lease and now this is, I'm right next to a corporate, I'm surrounded by factories or something now. It's no longer a neighborhood where that serves a community. So for a grocery. So I see breaking it up for reasons like that, but I can't see how, my understanding, how you could now not give a very specific reason to terminate tenancy.
Well, I guess, Judge, I guess that's where, my suggestion for an evidentiary hearing would maybe clear this up. The second lease that purported to cure it, we're all acting like it was undisputed. It's not. We have not stipulated to that, to that second amendments.
How many years ago was that done? That amendment?
January 5th, 2006.
2006. Okay. All right. If that was done in 2006, and this is 2022, and there's been no objection to it, to me that looks like that's been waived. It can't be. Well, that's in contention for, by exaggeration, for 20 years, and no one's addressed it and said, and so now we're going to say, well, I don't think the company actually existed then, then, right. But if there was an amendment where we get down and say, now we're changing it for this reason, and do we have all parties and signatures on that amendment?
Yes, Your Honor.
My client wasn't involved. I'm sorry.
All right.
So Judge, I guess to that, that also supports my same argument that in 2018, when the membership interest purchase agreement was affected, how is that, invalid or, in question based on those same principles?
Well,
Because that was
if
done in
nobody
2018.
objected,
No one
if-
objected
if-
to it until this eviction was filed. Now there's a deck action filed. Now just complaining that he doesn't have that authority.
But still, an eviction still has to have a reason for it. Unless it's at the natural conclusion and you're just looking to see if you're just gonna continue with the agreement. All right, so let me put it this way. The last, and I keep saying many agreements for not having, or many leases for not having a better way of stating it, because it was succession of how many leases that went out for how many years?
The original lease is in 2002. It was for 5 years with 5 additional 5-year term
5 years.
options at the tenant's sole expense. There were 3 amendments to the lease. The first amendment just had to do with who was maintaining the property, and that was done in 2002. The second amendment cleared up the name issue of the original landlord. That was January 5th, 2006. The third and final amendment, dated July 27th, 2021, granted 10 additional 5-year terms to the lease.
Okay, but it granted additional 5-year terms, but each term has a termination date that could be exercised by just giving a notice to quit in timely fashion, correct?
No, because it's the tenant's sole option. The landlord does not.
Okay, it's the tenant's sole option. Other than that, yes. So, well, counsel, I can't see any way around this because it's the tenant's sole option to renew, but the plaintiff will always have the option to ask for an eviction for cause. I don't see any cause out here. And the cause would be something that would be stepped out in the lease agreement. So you can't just say, well, go ahead.
I was gonna say I guess the most recent document, the Third Amendment, we're arguing that there's no standing for this Third Amendment because Eddie Barash, one, is not the manager or wasn't the manager at the time of the entry into this contract, and also because there's no mutuality. He basically gave himself an additional 50 years without my client being able to object to it in the midst of,
And what date was that done?
That was done on July 27th, 2021. And keep in mind that my client signed the membership purchase agreement in 2018, buying the majority.
Counsel?
Your Honor, my client was still the active manager on July 27th, 2021. Just because you buy a membership interest doesn't automatically mean you're the manager. The bylaws or the operating agreement of Value Safe Property LLC designates a manager of who is to manage the LLC. And on July 27th, 2021, that's Eddie Barash. And that's also admitted by Mr. Richardsville client because it was a month after, on August 20th, 2021, when they sent a letter to Mr. Barash Caro's counsel that they purportedly tried to remove Mr. Barash as manager, meaning they admit he was a manager at least as of August 19th of 2021.
Okay.
And for the record,
but again, Your Honor, that's still a red herring because even if this Third Amendment is set aside, you still have the original lease agreement with lease options extending through 2032. With or without the attempted purchase of Mr. Satama membership shares in 2018.
So the only addition to the Third Amendment was the additional time.
Correct.
And this happens outside or before we even get to the additional time frame that was given in the third agreement. So anything, wow. All right. Counsel, I don't think this is sufficient notice to ask or to evict anyone if in fact, because I don't see, how do you go to court and argue that I shouldn't be evicted? Well, I mean, I know how you argue it. I shouldn't be evicted because the complaint to recover possession of property does not allege any violation, just saying I want to terminate tenancy when I'm in the middle of an active 5-year contract. And you've not detailed anything to show that you had the legal right to break the contract or that I have violated any tenets of the contract. It would make contract more whimsical. I don't want to go through it anymore, and I'm going to send a notice to quit and termination of tenancy, and you have to go. And even though I have a long-term contract, you've not alleged any valid reason to terminate.
So, Your Honor, we're operating under the presumption that the Second Amendment to this lease is valid, and it actually did.
Yeah, I am, because I'm doing it for a couple of reasons. One, it's what year was it, Counsel?
January 5th, 2006.
4 years
Yes.
after it was admitted that the landlord did not exist. So for 4 years, they had a non-existent landlord that they must have known of that didn't exist operating this, and then they say, oh, wait a minute, let's change this in 06. And so that's why do we presume that's right? That
No, it's not. It's just if one party makes a determination for whatever reason that there's something deficient in the contract, and they decide to go forward and place it out to the world and say, hey, we're going to do amendment on this because this is wrong, or this is bad, or this is insufficient. So we're going to do an amendment on it, and we're going to fix it. I mean, that's the way you're supposed to do it. If you recognize that that contract is not working in your best interest because one, either by malfeasance, misfeasance, mistake, or just now recognizing that, hey, this is not the actual owner or manager or whatever term we're using at this particular time. And I'm going to go back to the parties and say, hey, let's do an amendment. Let's fix what is bad. And that's what they did in 2006. And that's been what they've been operating with since then. And now we get to 2022, and somebody wants to say, well, I want to end the agreement. And it has to be a valid reason to do so. I mean, landlords for individuals in houses have to give a reason for putting someone out during a time in the middle of a lease.
Understood.
They have to show that, they got a drug operation going on, or it's a brothel or other activity or something that's going on that's unsafe to property. But they have to step out what the reasons are for putting someone out, as opposed to just serving notice that we want the property back.
Because
you could do that at the end. You could do that at the end of the contract, but you can't do it in the mid-contract. You've got to have a valid reason for
Your
it.
Honor, so our
And
valid reason,
and I don't see anything.
our valid
Pardon
reason
me?
was, this is, again, when we operate on the presumption that the Second Amendment was proper, or that it did what it purports to do, which I received in the reply to the motion to dismiss. It could have easily been sent to me at the outset saying, hey, this is the wrong company, we had to do this amendment way back when, but it wasn't. It was in support of this motion to dismiss. I think in light of that evidence that we didn't have, I should at least be afforded an opportunity to amend my complaint, speak to my client if that's, something the court would entertain, or to have an evidentiary hearing on that. Because we can't make a finding that this contract was correct, that fixed a contract that was indisputably not a binding contract because that tenant or that landlord did not exist. It was not a valid entity.
Well, you can if you come back and you open that up to the world and say, hey, we're changing this for a reason. We're changing it because this is not the right company or the right person, and we give everybody an opportunity to see it and read it and sign off on it. So I can't go back in time and say, well, I signed off on it. Obviously I don't mean you personally, but someone signed off on that amendment, which is stated that there was something that was wrong with the pleadings on the earlier case, and the entity that we put out there is not the actual entity. We've been operating for some period of time with that wrong, but today we recognize it and we're going to fix it and then go forward with the actual rightful owner, tenant, landlord, whomever you are in this particular case. And once they did that and everybody signed off on it, you can't go back and say, well, they originally were not the right party because that didn't exist. And then they come to you and say, at some point in time, say, hey, this doesn't exist. So we're fixing it to something that is the rightful company. They did that back in 2006. So you can't now say, well, they were not an actual company.
I would say
they made amendments and added. I'm sorry. Go ahead.
I'm sorry, Judge. I would say that they purported to do that, and then in the middle, since we're now here in the middle of this, term, the landlord and the tenant are the same person that executed this third amendment. So they said, we're in the middle. So now we're gonna, now the landlord and tenant are both bound for another, basically a non-cancelable 50-year lease that's signed by Eddie Barash.
Well, that can't be the case, is it, counsel? Because why would you have a lease agreements that are broke up into 5-year intervals if they're non-cancelable? What's the point in having those intervals? Why not just say, I'm giving you a lease from now till 50 years from today? Why won't you just do that as opposed to saying it's renewable every 5 years?
If facts and circumstances change from a business perspective, if they don't want to have that type of contractual obligation.
Right, and that's what I understand, but I'm just saying that's a perfect reason to do that, and I don't know how you can now say, well, we're not. When you say it's a 50-year contract, it's not a 50-year contract. It's a 5-year contract that's renewable.
With 10-year
term. That's a distinction, or 10 years, 5 years, whatever it is. It has increments that that lease is just through that period, and then it's renewable after that. It's not a 50-year contract.
And there's
in effect, if both parties are still seeing eye to eye, it can go out to 50 years, but it's not. You put the brakes in there for a reason.
Judge, and both parties in this case for the Third Amendment is one person. Eddie Barash. He signed defendant's client in the middle of this, decided, okay, let's make this, even more in my benefit, and signed on behalf of ValueSave Inc. And then also signed on behalf of ValueSave Property LLC in the middle of this term, extending it for 10 5-year options is where I get the 50.
You know what? I understand that, and on its face, it sounds like some shady dealings to me. But if all parties signed off on it, what do you do?
No, not all parties signed off on it, Judge. Only one person, one individual signed on and purported to sign on behalf of ValueSave Property after the membership interest purchase agreement 3 years after.
Did the one person who signed off on it have the legal authority to do so?
Yes, he did.
You'd say no. They claim yes.
So that's what this case turns on. If the person was that Eddie Barash?
Yes.
If Eddie Barash actually had the legal authority to do so, if he had the legal authority to do so, this is a non-starter because. But if he and what questions his authority? I mean, he's a 60% owner of 40. The company, right? 40. All right, he's 40.
I'm sorry. To be very specific, he is the fix me or correct me if I'm wrong, but Barash Holdings is held 100% by Eddie Barash, and Barash Yusuf Holdings holds a 40% stake in ValueSave Property LLC, my client in this case. My position is that the member manager is the 60% owner, who is Wissam Satam, which is the evidenced by the membership interest purchase agreement that's attached to our pleadings in this. So my it's undisputed that
so Wissam is not a party to your lawsuit though, right? He's not. I mean, he's not. So I mean, he's not coming forward saying no, this was this is no longer a valid contract. He's not saying that. What's his position on there if he's the 60% owner?
Your Honor, I actually attached it to my reply brief. The operating agreement for Value Safe Property LLC. And on page 6 in section 6.1, management of the company, it clearly says the initial manager shall be Eddie Barish. And he continued to be the manager up and through at a minimum August 20th of 2021, when Mr. Satam's attorney sent a letter to Mr. Barish's attorney, us, purportedly trying to remove Eddie Barish as a manager.
And to remove him, when you say to remove someone, is that a recognition that at that time, prior to removal, he is the actual manager?
That's how we interpret it. Why, if he's not a manager, why would you seek to remove him?
Because he wouldn't give my client access to checks, things of that nature. He wouldn't give over the books after the so my client bought a 60% membership interest that wasn't a membership, and he wasn't given any of the financials, none of the leases. So at the time he was given these, they said, oh, well, let's hook on for another 50 years before, you know, all this stuff gets turned over when the heat started getting on. And that's how we wound up here.
But Judge, this is still all a red herring with this third amendment to the lease, because the original lease still had 5 options of 5-year renewals, which could take a leasehold interest through 2032.
Yeah.
If it's a red herring, let's rule that it's invalid.
Well, that's not what he's saying. What he's saying is, even without considering the additional 5 years, however many years the additional, we're still within the working time frame of the original contract. I think that's what he's saying. So he said, when we discuss what the new contract is, that is a future contract, and we're still dealing within the time frame of the current.
No, Your Honor, I don't believe that to be the case, because this third amendment states that it amends the very agreement we're talking about, right in the plain language of it. So that original contract is this third amendment.
But isn't the third, it's the third agreement that changes a third amendment. It's the third amendment that changes 2 things. It changes the recognition of who the corporate name is. Was that the third amendment?
No, the second amendment changed the corporate name in 2006.
Okay, second changes the corporate name. The third one just changes, it adds the additional years, and it talks about who the manager is. Is that correct?
No, it does not address the manager. It only addresses
just the time.
Additional options of term. And also the third amendment is an amendment. It does not replace the original contract. It is just strictly an amendment to include additional options to extend.
And I disagree with that, because it states that right in the plain language that it amends section 4 of the lease agreement, the original 5 options, to be an additional 10 options. So we're working on the same document.
Same thing. That's the same thing Mr. Lewis was saying. It just makes some amendments. It changes some things. The majority of the contract is the same. It just stipulates or states in plain language what is changing from the original, and it's amended to it. And the original contract now with these amendments are the contract that's going forward.
Well, and it changes rent, it changes everything, and it doesn't say, you know, specifically when this is happening. It relies on the original agreement.
Well, I think that's what amendments do. It relies on the original agreement with the additions or subtractions or whatever the amendments are. But other than that, if it's not addressed as an amendment, the portions that are not touched or are remain the same. That's what I understand.
And that's exactly what's stated in paragraph 3A of that.
All right. All right, counsel, I know you want to have a hearing of some sort. I'm not sure how what could be said, because this seems like it's pretty much clear in plain language to me that there was an amendment. The amendment states what they could do. That's what happened. And quite frankly, counsel, I don't see how you could ever get around the complaint to recover possession of property without some type of notation in here, because when you look to F on the complaint to recover possession of property, the plaintiff has the right to possession of the property because lease expiration, no check. Lease terminated per provisions in the lease, no check. Forcibly entry was made, no check. Defendant is a trespasser, no check. Other, no check. The check, the X is in the box that says Tennessee was terminated by notice to quit, which is insufficient in a case where there's an active lease. You would have to show a lease violation or criminal activity or some under other. You could have put
Or
in there.
challenge the validity of the lease, and that's what we're doing here, Judge.
Yeah, but what you're saying is you're challenging the validity of the lease that has been active for X number of years, and there's been amendments to it. And the only amendment to it is that there was a change in a person's status. Is that correct?
No, the amendment was the amendment one was just over who maintains certain aspects of the property. The second amendment cleared up the original landlord name that was an issue.
Okay.
And the third amendment was the the extension or additional
Extension, right? And none of those seem like they would be anything that would that they would be legal or something that would not be done in a normal operation of a long-term contractual relationship. So I think you would have to put in here in X that says the reason for the termination, as opposed to notice to quit. Notice to quit only works when you have and even then with the notice to quit, if it is for illegal activity or something of that nature, or something that's in total violation, as I gave earlier, where this is an operating supermarket and now you're going to add a marijuana dispensary or something like that, something that is clearly not intended on the original lease. But just to say we're terminating it by notice to quit, the notice to quit only states that I'm giving you 1 month to vacate the property. That's normally done in a case where a person has a finite contract period, and we've come to that end of the period, and we say, I'm not going to extend your lease agreement future-wise. Other than that, you normally and almost always have to give a reason for the termination, as opposed to it's at the end of the contract and we're not renewing it.
We're not stating it. We're saying the contract was never valid in the first.
No, I understand that, but I can't find that to be the case if the contract is 6 years old. Pardon me?
I would say the plaintiff shouldn't have to comply with a contract that does, the timing issues are one thing, and I understand that, but if you look at it as, okay, this contract never existed, so the terms within it and the period of time, none of that matters.
But aren't there other documents that state that this man is the manager?
Not that
I mean, so there's nothing. Okay, all right. Count the Attorney Ladas. Is there something that's stated that is open and transparent to the world who the manager is?
Your Honor, to my reply, it's Exhibit F, which is the operating agreement for Value Safe Property LLC. Paragraph 6.1 on page 6 says the initial manager shall be Eddie Barish.
I don't think we can get around that, counsel. So I'm going to have to rule in favor of the defense.
Understood.
All right. All right, counsel, you're gonna send me the paperwork for me to sign?
Which would be, Your Honor, granting my motion to dismiss.
Yes.
I also ask for costs and sanctions to Your Honor.
I'm sorry, you're asking for?
Costs and attorney fees. Because there's no basis to file this action.
And Judge, the admission of the first party to the lease not being an active entity, the membership interest purchase agreement that I attached here to, the assignment as a member, the fact that it's not disputed my client owns 60% of Value Safe Property LLC, I think sanctions need to be.
I don't believe this was frivolous. It is a different point of view. It is certainly an argument that can be made. I think the timing on the argument is a little older, but for me to award cost and sanctions, I truly believe that should be a case where it is frivolous. It is no attorney could ever ask for that. I think they had strong arguments. I just don't agree with them. Certainly, I don't believe it is frivolous, and I'm not going to award. The case will be dismissed, but I'm not going to award sanctions and attorney fees.
And that's without prejudice, Judge, of course.
Yes, it's without prejudice.
Okay, Eric, if you want to just send that over.
I'll send you a draft before I submit it to the court.
All right, thank you.
Have a good day, gentlemen.
Thank you, Judge.
You too, Judge. Thank you for taking the time, and sorry for clogging up your docket here.
Oh, no, it's my job. Thank you, sir.
Thank you.
Have a good one.